Here, two constitutional provisions were dispensed with were repealed by way of an definition clause, not like unlike interpretation clause. Here, kindly bear one factor in mind. 370 sub-article 3 has an inbuilt extinguishing provision. 370 sub-article 3 is a provision whereby 370 can be extinguished. That's the distinction. But I'm on a little wider argument made by the other side. Para 19, the submission, my Lord Justice. The submission advanced by Mr. Sorabji, the learned senior counsel appearing on behalf of the writ petitioner in writ petition number so-and-so are thus Article 291, 362 and 366(2). 366(2) is the definition clause defining princes then of the Constitution, were integral part of the constitutional scheme and form the important basic structure, since the underlying purpose of these articles was to facilitate submission of new order and ensure organic unity of India. These articles guaranteed pledges to the rulers based on elementary principles of justice, and in order to preserve the sanctity of solemn agreements, it was only by the incorporation of these articles that the unity of India was achieved by getting all the rulers within the fold of the Constitution, and that the deletion of these articles has damaged and demolished the very basic structure of the Constitution. The covenants entered into were in the nature of contracts which had been guaranteed constitutionally and affirmed by making the Privy Purse an expenditure charged under the Consolidated Fund of India, and the use of expression guaranteed or assured by the Government of Dominion of India to any ruler as embodied in Article 291, and the expression guarantee and assurance given under such covenants or agreements as is referred to in Clause 1 of Article 291 as comprised in Article 362 was a permanent feature of the Constitution, reflecting the intention of the founding fathers of the Constitution, and as such, these two articles should have been kept intact. Please pause here for a minute. My Lord, these articles even remotely did not suggest that they are temporary. As against, my Lord, 370, which by its very definition says it's temporary, and I will also, my Lord, be able to attempt to demonstrate that it could never have been but for temporary. Such a drastic provision, the visionary fathers and mothers of the Constitution would never have kept it permanent, where two organs can change the Constitution the way they like. But that's a separate argument. Please see. According to the learned counsel, the deletion of these articles amounted to a gross breach of principles of political justice enshrined in the preamble by depriving or taking away from the princes the privy purses which were given to them as consideration for surrendering all their sovereign rights and contributing to the unity and integrity of the country, and that the deletion of these articles by the Impugned Amendment Act is arbitrary, unreasonable, and violative of Article 14 of the Constitution. Further, it has been urged that rulers acceded to the dominion of India and executed instrument of accession and covenants in consideration of the pledges and promises enshrined in Article 291 and 362, and that the Impugned Amendment Act is beyond and outside the scope and ambit of the constitutional power of Parliament to amend the Constitution as provided under 368. Mr. Sorabji, in his additional written submissions, has further urged that without the cooperation of rulers, not only the territory of India, its population, the composition of the state legislatures, the Lok Sabha, the Rajya Sabha, but also Constitution that was adopted on November 26, 49, would have been basically different, and that India, that is Bharat, would have been fundamentally different from the Bharat that came into being. But kindly see, my Lord, para 22. Mr. Salve, the learned senior counsel, contended that he was also for the petitioner, my Lord, with Mr. Lord Sorabji.
But estoppel doesn't apply to him.
Pardon?
Estoppel doesn't apply to him based on what he argued in that case.
Well, that's the my Lord, privilege on this side. We are not bound by our arguments, my Lord. Mr. Salve, learned senior counsel, contended that Article 291 and 362, when Yes. Mr. Salve, the learned counsel appearing, contended that Article 291 and 362 when incorporated, were intended to grant recognition to the solemn promises on the strength of which the former rulers agreed to merge with the Indian Dominion, and the guarantee of privy purses and certain privileges was as a just quid pro quo for surrendering their sovereignty and dissolving their states. It has been stated that constitutional guarantees and assurances promising continuance of privy purse as enshrined in the agreements and covenants were an integral part of the constitutional scheme and an important part of the constitutional structure, and they were to be fully honored and not cast away on a false morass of public opinion or buried under the acts of states. But the impune ex specie has abolished and destroyed those constitutional provisions of Article 291 and 362 affirming the guarantees and assurances given to the rulers under those agreements. Then your lordships may kindly come to para 23. It is further emphasized that Sardar Patel, who made it clear that according to the vision and views of the constitution makers, the guarantees of privy purses, privileges, etc. were perfectly in keeping with the democratic ethos and principles of Indian people. Then the learned counsel stated that views expressed in the Constituent Assembly were unanimously accepted and there was no dissent, and that in fact the closing remarks in the debate of Dr. Patabi Sitaramaiah were only remarkably confirmatory of the permanence and indefeasibility of the aforesaid guarantee and assurances, but also went a long way in determining that the said guarantees and assurances have come to stay as an integral and untouchable part of the basic structure of the Constitution. Finally, it was said that there can be no basic structure of a constitution divorced from the historical evolution of precepts and principles on which the Constitution is founded. Any effort to determine the basic structure of the Constitution without keeping a finger on historical pulse of the Constitution may well lead to substantial injustice. According to him, if the historical approach to the test of basic structure is kept in view, the guarantees and assurances of the privy purses, privileges, etc., granted by the constitution makers by incorporating Article 291, 362, and 36622 in the constitution framed by them would, without any doubt or dispute, emerge in their own right as basic features of the constitution which cannot be abrogated or annihilated by any constitutional amendment, etc. Now, your lordships and my lord, kindly see para 28 at page 551. The learned Attorney General of India, with regard to the above pre-constitutional agreement, stated that the history of the developments leading to the merger agreements and framing of the Constitution clearly show that it is really the union of people of native states with the people of erstwhile British India, and the instruments of accession were only the basic documents but not the individual agreements with the rulers, and therefore to attribute the agreements entered into by rulers as a sacrifice by the rulers is unfounded. Secondly, the nature of the covenants is not that of a contract, because a contract is enforceable at law, while these covenants were made non-justiciable by a constitution vide Article 363. According to him, the covenants were political in nature, and that no legal ingredients as the basis can be read into these agreements, and that the guarantees and assurances embodied in Article 291 and 362 were guarantees for the payment of privy purses. He has urged that such a guarantee can always be revoked in public interest pursuant to fulfilling a policy objective or the directive principles of the Constitution. That being so, theory of sanctity of contract or unamendability of Article 291 or 362 did not have any foundation. He continues to state that the theory of political justice is also not tenable because political justice means the principle of political equality, such as adult suffrage, democratic form of government, etc. In this context, your lordships can skip, my lord, the citation. Then para 29. Before embarking upon a detailed discussion on the various facets of the contentions, both factual and legal, we shall deal with the precursive point with regard to the pre-constitutional instruments of accession. the merger agreements, and the covenants which guaranteed the payment of privy purses and recognition and personal privileges, etc., and which the agreements ultimately facilitated the integration of these states with dominion of India. Then, my lord, 30, your lordships may skip its history, 31. This accession of Indian states to the dominion of India established a new organic relationship between the states and the government, the significance of which was forging of a constitutional link or relationship between the states and dominion of India. The accession of Indian states to dominion of India was the first phase of the process of fitting them into constitutional structure of India. The second phase involved a process of twofold integration, the consolidation of states into sizable administrative units and their democratization. Though high walls of political isolation had been raised and buttressed to prevent the infiltration of the urge for freedom and democracy into Indian states, with the advent of independence, the popular urge in the states for attaining the same measure of freedom as was enjoyed by the people in the provinces gained momentum and unleashed strong movements for the transfer of power from rulers to the people. On account of various factors working against the machinery for self-sufficient and progressive democratic setup in the smaller states and serious threat of law and order in those states, there was an integration of states, though not in a uniform pattern in all cases. Firstly, it followed the merger of states in the provinces geographically contiguous to them. Secondly, there was a conversion of states into centrally administered areas. And thirdly, the integration of their territories to create a new viable units known as Union of States. My lord, your lordships may, my lord, now come to para 38, my lord, at page, my lord, 554, PDF 554. Now, my lord, the Honorable Court discusses Madhav Rao, because Madhav Rao obviously was cited. That which said that privy purses are an integral part of the Constitution of India. That is one. And number two, that you could not have taken it away by merely deleting the definition of princes. These were, my lord, the two. Then 38. On May 14, 1970, the Constitution 24th Amendment Bill for abolition of the aforesaid privy purse, privileges, etc., conferred under Article 291, 362, and 36622 was 366-22 was introduced in Lok Sabha by the then Finance Minister Sri Chavan. The bill contained 3 clauses and a short statement of objects and reasons. The statement reads as under: the concept of rulership with privy purses and special privileges unrelated to any current function and social purposes is incompatible with an egalitarian social order. Government have therefore decided to terminate the privy purses and privileges of rulers of former Indian states. On September 2, the bill was voted upon in Lok Sabha, but on September 5, Rajya Sabha rejected the same since the bill failed in the Rajya Sabha to reach the requisite majority and not less than 2/3 present as required by Article 368 and voting. Close on the heels of the said rejection, the President of India, purporting to exercise his powers under Clause 22 of Article 366 of the Constitution, signed an order withdrawing recognition of all rulers of the country en masse. Look, this was the subject matter in Madhav. A communication to this effect was sent to all rulers in India who had been previously recognized as rulers. So what was done was, by a constitutional order, which is unheard of, my lord, except in 370, the Honorable President virtually declared 2 provisions to be nullity. The presidential order, para 40, de-recognizing the rulers were questioned in Madhav Rao, Scindia versus Union of India by filing writ petition under Article 32, challenging it as unconstitutional, ultra-virus and void. An 11-judge bench of this court, by its judgment dated so-and-so, struck down the presidential order being illegal, ultra-virus and inoperative on the ground that it had been made in violation of power of the President of India under Article 36622. of the Constitution and declared that writ petitions would be entitled to all their pre-existing rights and privileges, including right to privy purses, as if the impugned orders therein had not been passed. Here, it may be noted that Justice Mehta and Justice Ray gave their dissenting judgment. Thereupon, that they started getting privy purses. Kindly come to para 77 at page 562. Rest, my lord, may not help, my lord, assist your lordships, my lord, either way. 77. According to Mr. Sorab, para 77.
That's one.
Your lordships would, I'm sorry, no, my apologies.
In the merger or the other agreements, that the President of India will recognize the ruler or something because of inheritance and otherwise. That was there.
Yeah,
That
but
was,
366.
there was some stipulation because those, the rule of primary nature and other things were all recognized in that. That's how.
Yes, but every ruler was
You are
apart
nodding
from.
the head because you argued that.
This guaranteed them not only privy purses, some privileges.
Correct.
All states were divided into gun salute states. Somewhere 21 gun salute, somewhere the smallest was one gun salute.
They did refer to presidential orders in that merger agreements also. No. At that time, there won't be any president as such.
No, my lord, there was none.
No. Because at the time when the agreements were signed, there won't be a.
Thereafter, the constitution was made and the honorable president was elected.
The petitioner.
No, merger agreements were signed by Dominion of India or subsequently Government of India by the Secretary, Minister of State, Ministry of State. VP Menon, Lord, essentially is the signatory.
And 75 make a brief reference.
Yes.
Para 74 and 75, there is a brief reference to all these agreements.
Correct. I'm okay. But your lordships are on para. But may I read para 75, lords? May I?
Yes, para 75.
75. Therefore, there cannot be, my lord, it is on page 561. Possibly that's what, my lord, the Honorable Court is reading. Therefore, there cannot be any justification in saying that guarantees and assurances given to the rulers were sacrosanct, and that Article 291 and 362 reflected only the terms of the agreement and covenants. In fact, as soon as the Constitution came into force, the memoranda of agreements executed and ratified by the State of Union of States were embodied in formal agreements under the relevant articles of the Constitution, and no obligation flowed from those agreements and covenants, but only from the constitutional provisions. To say differently, after introduction of Article 291 and 362 in the Constitution, the agreement and covenants have no existence at all. Everything gets subsumed in the Constitution itself.
In fact, that is the proclamation which Karan Singh issued after the adoption of the Indian Constitution. That thereafter, the entire relationship will be governed by the Indian Constitution.
Yes.
And all previous covenants, agreements will cease to have any application.
They are, my lord, therefore, I said, my lord, it gets subsumed. And now the final document is the Constitution of India, which we have given to ourselves. To say differently, after the introduction of Article 291 and 362 in the Constitution, the agreements and covenants have no existence at all. The reference to covenants and agreements was casual and subsidiary, and the source of obligation flowed only from the Constitution. Therefore, the contention urged on the use of the words guaranteed or assured is without any force and absolutely untenable. The next vital issue is whether the Impugned Amendment Act damaged any basic structure or essential feature of the Constitution. According to Mr. Sorabji, the repeal of Article 291 and 362, which were an integral part of the constitutional scheme, the identity of the Constitution has been changed and its character has been fundamentally altered. The total repeal of these articles, coupled with an express repudiation of the guarantees embodied therein, has resulted in nullification of a just quid pro quo, which were the essence of these guarantees. He has urged that the underlying purpose of doing justice to the rulers has been subverted and breach of faith has been sanctioned. He has relied upon these judgments, including, my lord, 3 is Madhav Rao Scindia. And please see, my lord, 79. Mr. D.D. Thakur, Lord, father of my Lord Justice Thakur. My Lord, the Chief Justice Thakur. D.D. Thakur, in addition to the above, has stated that one of the tests to determine whether the provision of the Constitution was intended to be permanent or could be deleted or amended is to see whether the Constitution makers had intended that to be made permanent. In support of this submission, he placed much reliance on the observations of Justice Mudholkar in Sajjan Singh. My Lord, I can skip that. And thereafter, my Lord, I may directly come to 88 at page 563. Your Lordship has my Lord Justice Govai and Justice Sorabji. Mr. Soli Sorabji, in support of his contention that Article 291 and Article 362 and Clause 22 of the Article 366 were integral part of the constitutional scheme, which otherwise would mean the essential part of the constitutional scheme referred to Webster's Dictionary and Collins' Concise Dictionary, and has pointed out the lexical meaning which says the integral means essential, and therefore, according to him, the total abolition of provisions of the Constitution, which are in its integral parts, otherwise essential parts, has damaged the essential and basic features of the Constitution. To draw strength for his submission, he relied upon certain observations made by Justice Shah in his judgment in Madhav Rao, observing, my Lord, now, my Lord, Madhav Rao is dealt with, my Lord, and distinguished. By the provisions enacted in Article 366(22), 291 and 362 of the Constitution, the privileges of rulers are made an integral part of the constitutional scheme, and an order merely derecognizing a ruler without providing for continuation of the institution of rulership, which is an integral part of the constitutional scheme, is therefore plainly illegal. The learned Attorney General has vehemently opposed the above submission, stating that the expression integral part of the scheme of the Constitution used in Madhav Rao are not the same as the basic structure, and that expression has to be read in the context of a challenge to the ordinance which sought to render nugatory certain rights guaranteed in the Constitution then existing. It is further stated that the attack on 26th Amendment based on principles laid down in Madhav Rao is totally misconceived, because only in order to overcome the effect of that judgment, the 26th Amendment was passed by Parliament in exercise of its constituent powers. The President exercised executive power, which he did not possess. Just to contrast, Article 370 has a constituent power in the President under sub-Article 3, the self-extinguishing provision. According to the Attorney General, the observations in the said case were nullified by the amendment, and the judgment is no longer good law after the amendment. To test the amendment on the basis of that judgment is impermissible, and all the arguments based upon this case are therefore misconceived. Then 91. After the commencement of the Constitution, in pursuance to Article 36622, the rulers were recognized and they had been enjoying the privy purses, privileges, dignities, etc. on the basis of relevant constitutional provisions. Pursuant to the resolution passed by All India Congress Committee in 1967, the Union of India introduced the 24th Amendment Bill in 1970 to implement the decision of the All India Congress Committee favoring the removal of privy purses, privileges, etc. But the bill, though passed in Lok Sabha, failed to secure the requisite majority in Rajya Sabha, and therefore it lapsed. It was only thereafter that the President of India issued an order in exercise of powers vested in him under Article 366(2), changing the definition clause by an ordinance. I'm sorry, my Lord Justice.
Please continue.
I'm sorry. 36622, de-recognizing the rulers and stopping the privy purses, privileges, etc. enjoyed by the rulers. Now, this is important, my Lord. This is the distinction. This order passed by the President was the subject matter of challenge in Madhav Rao 2. The Supreme Court struck down the order of the President as invalid, as in the view of the Court, de-recognition of rulers would not take away right to privy purses when Article 291 and 362 were in the Constitution. This is the ratio, that you can't delete a definition while retaining the constitutional rights guaranteed under 291 and 362. It was only in that context the observations which have been relied upon by Mr. Sorabji were made. The 26th Amendment itself was passed by Parliament to overcome the effect of this judgment. Now, by this amendment, Article 291 and 362 are omitted. Article 363A is inserted and Clause 22 of Article 366 is amended. Therefore, one cannot be allowed to say that the above said omitted articles and amended clause were the essential part of the constitutional scheme. So, they have to be read only in the context of a challenge made to the presidential order, which sought to render nugatory certain rights guaranteed in the Constitution, which were then existing. In any event, the constitutional bar of Article 363 denies the jurisdiction of any court in disputes arising from covenants and treaties executed by the rulers. The statement of objection reasons of 26th Amendment clearly points out that the retention of the above articles and continuation of the privileges and privy purses would be incompatible with the egalitarian society assured in the Constitution, and therefore, in order to remove the concept of rulership and terminate the recognition granted to ruler and abolish the privy purses, this amendment was brought. Now, 92 is very important, my Lord, which would also assist your Lordship on the question of federal diversity. We are of the opinion that the observations of Justice Shah in Madhav Rao that privileges of rulers are made an integral part of the constitutional scheme, and that the institution of rulership is an integral part of the constitutional scheme must be read in their proper context. That was a case whereby a presidential order, the rulers were deprived of their privy purses and other privileges while keeping Article 291 and 362 intact in the Constitution. This doesn't arise here, my lords. Indeed, the said presidential order was issued after the government failed in its attempt to effect an amendment on those lines. It is in that connection that learned judge made the above observations. It is clear that the learned judge used the word integral part in their ordinary connotation, not in lexicographical sense. Ordinarily speaking, integral means of a whole or necessary to completeness of a whole, and as forming a whole. Our constitution is not a disjoint document. It incorporates a particular socio-economic and political philosophy. It is an integral whole. Every provision of it is an integral part of it. Even the provisions contained in Article 21, temporary, transitional, and Part 21, temporary, transitional, and special provisions. One may ask, which provision, which concept, or which institution in the Constitution is not an integral part of the Constitution? He will not find an answer. To say that a particular provision or a particular institution or concept is an integral part of the Constitution is not to say that it is an essential feature of the Constitution. Both are totally distinct and qualitatively different concepts. The said argument is really born of an attempt to read a judgment as a statute. One may tend to miss the true meaning of the decision by doing so. We may say the aforesaid observations of Justice Shah constituted the shit anchor of the petitioner's argument relating to the basic structure. My lord, just similarly, federalism is also, my lord, a basic structure. But the federal diversity can still exist within federalism. But my lord, that's a separate issue. In the above premise, it is not permissible to test 26th Amendment with reference to observations made in Madhav Rao. Lord, now kindly come to para 96 at page 566. Yeah. Permanent, your lordship, yes. Para 96 at page 566.
Yes.
Permanent retention of the privy purse and the privileges of rights would be incompatible with the sovereign and republic form of government. Such a retention will also be incompatible with the egalitarian form of our constitution. That is the opinion of the Parliament, which acted to repeal the aforesaid provisions in exercise of its constituent power. The repudiation of the right of privy purse privileges, dignities, etc., by deletion of Article so-and-so, which the recognition of the rulers and payment of privy purse are withdrawn, cannot be said to have offended Article 14 or 19, 1F. And we do not find any logic in such submission. No principle of justice, either economic, political, or social, is violated by the 26th Amendment. Political justice relates to the principles of right of the people, that is, right to universal suffrage, right to democratic form of government, and right to participation in political affairs. Economic justice is enshrined in Article 39 of the Constitution. Social justice is enshrined in, the Lordships can skip that. 97. A serious argument has been advanced that the Privy Purse was a just quid pro quo to the rulers of Indian states for surrendering their sovereignty and rights over their territories, and that move for integration began on a positive, promising note, but it soon degenerated into a game of maneuver, presumably as a deceptive plan of action. This argument, based on the ground of breaking of solemn pledges and breach of promise, cannot stand much scrutiny. To say that without voluntary accession, India, that is Bharat, would be fundamentally different from that Bharat that came into being prior to the accession is untenable, much less inconceivable. Please mark this, Malad. Beautiful words. One should not lose sight of the fact that neither because of their antipathy towards the rulers nor due to any xenophobia did the Indian government entertain the idea of integration, but because of the will of the people. It was the people of the state who were basically instrumental in integration of India. It would be apposite to refer to the observations of Justice Bose in Virender Singh's judgment. Every vestige of sovereignty was abandoned by the dominion of India and the states and surrendered to the people of the land who, through their representatives in the Constituent Assembly, hammered out for themselves a new constitution in which all were citizens in a new order, having but one tie and owing but one allegiance, devotion, loyalty, fidelity to the sovereign democratic republic that is India. Thereafter, it is also worthwhile to take note of the historical process of states' integration. Lord, your Lordships may directly can come to 109 at page 569, 107. On a deep your Lordship gets me, my Lord. Para 107. On a deep consideration of the entire scheme and content of the Constitution, we do not see any force in the above submission. In the present case, there is no question of change of identity on account of 26th Amendment. The removal of Article 291 and 362 has not made any change in the personality of the Constitution, either in its scheme or in its basic features or in its basic form or its character. But please read 370 in this. Does it change the personality of the character of the Constitution? The question of identity will arise only when there is a change in the form, character, and content of the Constitution. In fact, in the present case, the identity of the Constitution, even on the test proposed by the Council for writ petitioners and interveners, remains the same and unchanged. Sri So-and-so has contended that by removing the real and substantial distinction between erstwhile princes forming a class and the rest of citizenry of India, the constitutional amendment has at one stroke violated the basic structure of the Constitution as reflected both in Article 14 and 51C and treated unequals as equals, thereby giving a go-by to a solemn treaty obligation which was sanctified as independent constitutional guarantee. 109. Malord, this is very, very important and crucial for our purpose, Malord, the purpose of the respondents. After carefully going through the above decisions which relate to service matters, we are afraid that such an argument as one made by Sri So-and-so could not be substantiated on the principles laid down in these two decisions, that Article 14 will be violated if unequals are treated as equals. In our considered opinion, this argument is misconceived and has no relevance to the facts of the present case. Please note this. One of the objectives of the preamble of our Constitution is fraternity, assuring the dignity of the individual and the unity and integrity of the nation. It will be relevant to cite the explanation given by Dr. Ambedkar for words fraternity, explaining that fraternity means a sense of common brotherhood of all citizens. No region, no part of the region, no citizen staying in any region should get any different treatment than rest of the country. In a country like ours, with so many disruptive forces of regionalism, communalism, and linguism, it is necessary to emphasize and re-emphasize that unity and integrity of India can be preserved only by a spirit of brotherhood. India has one common citizenship, and every citizen should feel that he is Indian first, irrespective of other bases. Therefore, I started by saying that a psychological duality in the mind is now completely gone. In this view, any measure, please mark this, in this view, any measure at bringing about equality should be welcome. There is no legitimacy in the argument in favor of continuance of princely privileges, since we have held that abolition of Privy purses is not violative of Article 14. It is unnecessary for us to deal with the cases cited, which according to him go to say so and so. Then 1110. One of the arguments advanced by Mr. D.D. Thakur is that the Constitution should be read in the context of a pluralistic society of India, where there are several distinct and differing interests brought together and harmonized by the Constitution makers by assuring each section, class and society preservation of certain political, cultural and social features specific to that class or section. By way of example, reference to Article 370, which confers a special status for Jammu and Kashmir, is made. He continues to state that likewise in the northeastern states, the tribals were given autonomous powers for their district councils co-equal to what is conferred on the states, and that the minorities special provisions are made in Article 30. Besides, Article 25 and 26 are meant to safeguard the minorities and religious denominations. The persons to determine the injury will be those for whom these provisions were made and whose interests are prejudiced. According to him, in such a circumstance, the assurance and guarantees given under Article 291 and 362, which are the Magna Carta, assuring the rulers of their pre-existing rights, cannot in any way be destroyed. We do not think that the aforesaid special provisions have any relevance here. As repeatedly pointed out supra, the only question whether there is any change in the basic structure of the Constitution by deleting Article 291 and 362 and by insertion of Article 363A and amendment of Clause 22 of 366. We have already answered this question in the negative, observing that the basic structure of the essential feature of the Constitution is or are in no way changed or altered by the impugned amendment. We cannot make surmises of its ifs and buts and arrive at conclusion that Article 291 and 362 should have been kept intact as special provisions made for minorities in the Constitution. It is but a step in the historical evolution to achieve fraternity and unity of the nation, transcending all regional, linguistic, religious and other diversities, which are the bedrock on which the constitutional fabric has been raised. The distinction between the erstwhile rulers and the citizenry of India has to be put an end to so as to have a common brotherhood. The court traces it to fraternity mentioned in the preamble. Lord, even removal of some provision according to this judgment can further the constitutional objective and can be in furtherance of the basic structure of the Constitution. Fraternity, equality is a basic structure of the Constitution. It's a part of brotherhood, it's a part of equality, part of fraternity. And if any provision which keeps out of the total composition of our Constitution as an appendage, as a transitory provision, to be removed at an appropriate stage, if it is removed, it furthers the basic structure and it enhances the equality and fraternity, which is the bedrock of the Constitution.
Yes.
So, my lord, in this view, my lord, in my respectful submission, may not be necessary to read Madhav Rao Scindia judgment. If your lordship would wish me, my lord, I can assist your lordship with that. But we will, my lord, ultimately read the same paragraphs based upon which, my lord, it is distinguished. that when you are doing something, earlier, my lord, it was done by a presidential order in Madhavra. One definition was deleted, which the president did never possess. Even today, it doesn't possess. But only in one provision, that is 370, where you can amend any part of the constitution. So explanation 367 mechanism is used. So this is the drastic nature of this provision. 371 permits two organs, the government of the president, my lord, president would mean act and advise, my lord, aid and advise, and the government of the state, again aid and advise. My lord, please, my lord, appreciate this. Two individuals, technically, the prime minister and the chief minister of the state, whoever he is, can make any change, can make any alteration, can choose not to apply any provision, and like 35A, can create a constitutional provision only applicable to Jammu and Kashmir. That provision is exercised now as a last exercise to ensure that it never happens. 367 explanation is added. I'll come to that. Of this. But my learned friend wants me to this. Yes, my lord, there is a concurring judgment, my lord.
Justice Mohan.
Justice Mohan, my lord. PDF 577, my lord. Just note the paragraphs, my lord. Para 151, 152, and 118, my lords.
180.
118, my lords. PDF. Okay.
6 morality.
Yes, my lords. Yes, I'm sorry, my lord. 206. It's at page, I'll just read, your lordship need not go to, it's a 2-line paragraph, my lord, but a very 594, my lord, PDF 594. This is, my lord, the concurring view, Justice Mohan, my lord, Justice Mohan. Therefore, this court cannot concern itself with the moral aspect of the impugn amendment. The impugn amendment is the will of the people expressed through Parliament. My lord, here the Parliament has examined on 4 occasions with 2/3 majority in both the houses. Lord, in Madhavrao Sindhia judgment, Lord, if your lordships can note the paragraphs which we would be reading. Lord, since it's already 11:45, my lord, I don't wish your lordships time, my lord. If possible, my lord, conclude at 1 o'clock. Lord, in Madhavrao Sindhia, my lord, we will be relying upon 97, 109, 119, 120, 125, 126, 143, and 145. And 145. But ultimately, it turned that without deleting Article 291 and 362, whether presidential order can be used, by deleting the definition only. That was the discussion, which is distinguished, my lord, in this judgment. Now, my lord, with your lordship's permission, my lord, I may go to...
Mr. Solicitor, can the abrogation stand independent of the modification which is made to Article 367 here?
Lord, that is my submission. Lord, even in absence of the proviso, Lord, explanation, the last explanation, what it does, it merely substitutes the term Constituent Assembly
with
legislative assembly. Lord, my submission is going to be that when the Constituent Assembly is dissolved without any recommendation, that part of the requirement goes, because proviso proviso becoming otiose cannot result into the main provision becoming inoperative. Then the president was left to his own choice. And 367 mechanism is affirmed, my lord, in Damnu, your lordships have seen. But so far as 370
what
is
was done in Madura was that a presidential order was issued. Because if you see the provisions of Article 366,
yes,
22, as it stood prior to the amendment by the 26th Amendment. If you have this red book, it may not be in that. You will have to get it in the red book at page 372.
yes, I'll just.
That said, ruler in relation to an Indian state means the prince, chief, or other person by whom any such covenant or agreement as is referred to in clause 1 of Article 291 was entered into, and who, for the time being, is recognized by the president as the ruler of the state, and includes any person who, for the time being, is recognized by the president as a successor of such ruler.
Yes.
Now, what happened there was, initially, after the proposed amendment didn't pass muster in the Rajya Sabha, a presidential order is issued, purportedly under clause 22. And the object was, now we are de-recognizing you. If you are being de-recognized, you lose the benefit of your privy purse in Article 291. That
presumed to be the consequence of de-recognition.
Right. So this was done in exercise of the power which was conferred under clause 22 as it then stood prior to the 26th Amendment. Our court said, look, by recourse to a presidential order, you cannot override a substantive provision of the Constitution, namely Article 291 and Article 362. That was Madhura's India.
Correct.
Then came the Constitutional Amendment, which was upheld against the challenge on the ground of the basic structure violation. Argument in this case is that what you have done essentially here is worse, because there was a presidential order in exercise of a provision in Article 366, which gave the president the power to recognize or de-recognize a ruler. Here what is being done is that 367 itself is sought to be amended in exercise of the, during the, we've seen
operating 370.
To amend 370.
Which has been done consistently and affirmed by your lordships. The distinction is twofold distinction. A, 370 is the only article, was the only article which permitted the president to change any other article. So 367, your lordships have shown, I have shown the chart, that 367 mechanism was used in past. That has been the convention. So the only thing which happened, my lord, on 5th and 6th of August was that using the mechanism of 367, the Constituent Assembly was changed. It is not worst. There, my lord, there is a...
The 367 mechanism which was used earlier to, for instance, substitute, the Sadari Riyasat, etc., that was with the concurrence of the Assembly.
No. Only once. That was 370 sub-article 3. This, my lord, use of 367 is, kindly, my lord, see the distinction. What was done with the concurrence was under 370 sub-article 3. Constituent Assembly was there in 1952, it recommended and a change was made. This time, it is under 371D. Lord, this time I may emphasize, my lord, so that I'm sorry, I was not clear. I'm sorry, my Lord Justice call was. My Lord, may I request your lordships to take 370 once again, my lord, for the time being. To make myself clear, my lord. That, my lord, would answer my lord's query, my lord, to my lord's satisfaction. Your lordships may come to, I'll show only two provisions, my lord. 371D. Your lordships have 371D, my lords.
Yes.
This is the first power. Such of the other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. Correct, my lords? Now read 3. Kindly read 3. Notwithstanding anything in the foregoing provisions of this article, the President may, by public notification, declare that this article shall cease to be operative. That is first part. Or shall be operative only with such exceptions and modifications and from such date as he may specify. This is the power of extinguishing or partly extinguishing. But now this is crucial, my lord, apropos my lord's question.
Yes.
The first exercise, as your lordships have rightly said, was under 3. Because the Constituent Assembly was in existence, it recommended. Rest, whenever there were modifications made in 367, were made under 1D. All rest, all under 1D, including this one.
With the concurrence of the government.
Concurrence of the government.
The reason for that was very simple, because you are amending the constitution and you are not dealing with subclause 3 of
3, yes.
you're not dealing with subclause 3
I'm not dealing. I dealt with at the end on, my lord, 6th of August.
because subclause 3 only deals with 370 itself.
Itself, not other, your lordships are right, not other part of the Constitution.
Because D refers to other provisions, because before D you have C.
Yes.
C says that the provisions of Article 1 and of Article 370 shall apply to the
Yes.
state of Jammu and Kashmir.
Correct.
Therefore, in that sense, it freezes the provisions of Article 370 in relation to the state of Jammu and Kashmir. Now, what it does is, therefore, it says, other provisions of the Constitution shall apply subject to such exceptions and modifications. Therefore, other provisions will mean provisions other than Article 1 and Article 370.
And 370 itself.
And 370 itself.
Correct.
Therefore, if you have to make an alteration of 370 or abrogate its status or reduce it or dilute it or alter it, you have to follow 3 equals to 3.
Correct, Manoj.
Right?
But, my lord, kindly, I'm sorry, my lord, I'm almost reaching, my lord, at your lordship's level.
But then
No.
can you do that? Can you do
Exactly,
that?
that's what I'm answering.
Using the power under 367 then. That's the point.
Exactly, that's what I'm answering. I cannot do that under sub-article 3. 367, I cannot modify under sub-article D. That I can do, and I have done only under 371D. It has been used as a mechanism, and Damnu approves it.
Right. We've seen Damnu.
Any-
We are now just looking at it. We are looking at it as a matter of first impression.
Correct, Manoj. The first impression.
Can you alter the import of a provision of Article 370 itself by a process other than 3? Because what you
No.
have done essentially here is
No.
that you have used 367 to amend the proviso to 370.
Correct. No, not amend. 367 is explanation. That instead of A, it would be B. It may have an effect of amendment.
Whether you call it an explanation or an amendment,
Yes.
one thing is very clear, that the amendment to 367 has the consequence of now reading the words Legislative Assembly in place of Constituent Assembly.
Which in fact was not necessary. But yes, it was done. But not under 370. It was done under the first step was, my lord, the first step was the President under 371D added the explanation that henceforth.
What the question being put to you is slightly, I think, different. The question is, by making the amendment in 366, by equating Constituent Assembly with the Legislative Assembly, aren't you in fact amending Article 370? Why, without taking recourse
to 373.
to clause 3 of 370, because Article 370 can be only amended in terms of clause.
Because of clause 3.
No, I understand. But then, my lord, it has the effect of it becoming permanent. Because there is no constituent assembly. So it can never be modified. 370 can never be modified.
Can take recourse. I mean, the argument on the other side is this, that you can take recourse to clause D of subclause D of clause 1 in a situation where you have to amend any other provision of the Constitution other than Article 370.
Lord, how?
But can you take, yes,
It doesn't say so.
It's very clear. It says
Such other provisions.
Other provisions of this.
Other means except 1 and 370.
So you are saying such other
Yes.
provisions will include 367. Mr. Solicitor.
Yes, it's
All right, Mr. Civil, just answer again. That doesn't matter. Let's not.
quite often. I think I should be accustomed to, my lord.
We are posing
Yes.
an issue because we have to deal with these issues. So we want to elicit a response.
Yes, my lord.
371D refers to other provisions of the Constitution. Other provisions of the Constitution, according to you, would include 367. Possible. We're not ruling this out at all. We'll test that hypothesis. But can you use 367 and amend 367 to bring about an amendment to 370? If you do that while exercising the power under 371D, then are you not really doing that to amend 370 itself? Because the only provision which the Constitution creates to amend 370 is 370 clause 3. What you are now doing is, according to them, is that you are using the amendment of 367, applying the provisions of 371D to bring about an amendment to 370 itself. Whereas the purpose of 371D is to amend some other provision of the Constitution. True, 367 is another provision of the Constitution, but can you use that to amend then 370 itself? That's the point which you have to answer.
Lord, I can assure my learned senior.
No, please.
No, I can assure him. Nobody can disturb me or derail me without my consent. I'm quite accustomed to such interruptions.
No, Mr. Solicitor, please don't get derailed because this is the heart of the matter.
No, I know that. My lord. And he also knows. But I'm quite accustomed.
Some clarity on this is necessary. Let's sit down and do
Lord,
it for
what
5
will
minutes
be,
and then
Lord,
we'll
I will
deal with
put
this
it
part.
slightly differently. I'll put it differently. The interpretation which your lordships are, my lord, prima facie now testing.
We're testing it.
No, we are testing it. The prima facie testing it. Lord, what will be the impact of that interpretation? I'll read, my lord, the entire Article 370. Meaning thereby, my lord, in absence of a constituent assembly, which can never be modified, the sub-article 3 can never come into effect, come into operation, and 370 gets the status of a permanent provision. Lord, please read it in totality. My lord, please read the entire article. My lord, for my satisfaction, please have a look at, my lord, the entire article. Notwithstanding anything in this constitution, your lordships can skip. The power of Parliament to make laws for the said state shall be limited to those matters in the union list and concurrent list. Your lordships have seen, my lord, those the precedent here. The provisions of Article 1 and of this article shall apply in relation to that state. The purpose is that Jammu and Kashmir can do nothing in their constitution, or even Parliament can do nothing in their constitution. So I really appreciate, my lord, the difficulty, my lord, if your lordships accept that. Then even 368 route, which is the second route suggested, cannot be done. Because it says 1 and this article shall remain. If that is the meaning given, that is completely unalterable, then 370 remains as a permanent, though there are a host of considerations for me to show that it has always been a temporary feature. Further, such of the other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. My lord, other provisions would mean other than B.
Yeah, just stopping you for a minute. Could the Legislative Assembly make a recommendation in terms of 371A saying that under 367 you equate Constituent Assembly with Legislative Assembly?
Under 371?
What D? 370 sub clause 1 sub clause D. Could the Legislative Assembly make a recommendation saying?
If it is amendment, it cannot. If
Just think about it and then answer. Could the Legislative Assembly make a recommendation to the Parliament, please amend Article 367 and
let me give it a thought and my lord respond to that. My lord, that I understand the heart of the matter. Your lordship's discussion, my lord, is driving that any 367 use which has the impact of altering 370 itself, then, my lord, we would be setting at not all 367 usages. But kindly remember, through the 367 mechanism, 370 has been modified.
That's the point in favor of what you are saying, with the caveat that the use of the 367 mechanism to modify 370 was always with the consent.
Concurrence.
Sorry, consent.
Here also it is concurrence. The only difference.
It was concurrence.
Yes,
That's
this is
the very one. That is constitutionally the significant difference.
But this is also with concurrence. Look, this is also with concurrence. The only difference is the concurrence of the governor, because governor steps into the shoes of the government.
So there's a difference between concurrence and recommendation.
Correct.
Concurrence can be subsequent. Recommendation has to be.
No, recommendation is of the body, Constituent Assembly as it stood, and subsequently, if we are right, Legislative Assembly. Concurrence of the government. Please see, my lord. And government, the only dispute was that government cannot mean governor. Please see, my lord, concurrence provision, second provision.
Concurrence of the government means that's Council of Ministers.
Council of Ministers, if it is there, otherwise powers are exercised by the governor. And that's why, my lord, I pointed out that there are several exercise of 371D when there was a precedence rule with concurrence of the governor.
At least you have provided yesterday.
At least,
At least you have read it yesterday.
yes. Yeah, my lord, your lordship's query is, my lord, absolutely, my lord, dot on the point. But, my lord, I'll respond, my lord. Let me give it a thought. But the real question would be...
You have already responded.
Well, the real question is, my lord, that here concurrence is that of the governor. Government, whichever is the government, if it is ministry, then cabinet, aid and advice, otherwise the governor. And during governor's rule, 371D is used to change 367 also. To not change is a incorrect word I am. To put an explanation, to give meaning to 370.
So simply put, according to you, at a time when there was no legislative assembly, the explanation was amended so as to incorporate provide that the Constituent Assembly shall itself be treated as the Legislative Assembly.
Because it was so treated.
Because the Constitution had not been framed and there was no Legislative Assembly in the state of Jammu and Kashmir. So according to you, the flip side now is that when there is no Constituent Assembly, we treat the Legislative Assembly as a Constituent Assembly.
To democratize, my lord. Otherwise, my lord, kindly see, suppose the government took the decision. The government took the decision, my lord, suppose.
The second answer could be, and that's for the other side to answer, by amending 367, in fact, you're not really amending 370 as such, because the 370 procedure has to be still applied. To abrogate or nullify 370, the procedure has to be still applied. Suppose 367 had been amended in terms of 371D with the concurrence of the state government. Second step, the Legislative Assembly had made a recommendation, please abandon or abrogate 370. It would have passed muster. Nobody would have really, probably the other side wouldn't have been here also, except some of them.
Yeah, they would still be here, but that's that's beside the point.
But it could have been done. If this route is permissible or not.
Lord, suppose I'm putting a question to myself. Lord, suppose
I thought I answered it in your favor.
Your Lordships are absolutely right. That's my answer, my Lord. That's my answer. I'm grateful to your Lordship, my Lord, for that. That thought didn't occur to me. But Lord, suppose we took the decision that in view of the proviso becoming otious, because there is no constituent assembly, that limitation of recommendation, ultimately it's recommendation. Suppose it recommends that don't abrogate. President is not bound by it. So now the Constituent Assembly, having chosen while being dissolved not to recommend, the Constituent Assembly has left it to the absolute discretion of the President. It could have been done, my Lord. Possibly it could have been defendable action, but with a view to ensure that there is democratization of the action. And my Lord, your Lordships are dealing with the state of, this is a provision which is one of its kind. There is no such provision either in our constitution or in any constitution. So the law which your Lordships would ultimately lay down is not going to, Lord, touch upon any other provision. If suppose the Common Constituent Assembly, while it was being dissolved, if it framed the constitution, it had options. A, don't abolish. I am recommending that President should not exercise powers under sub-article 3. He should not abrogate 370. That was the first option. Second option, he should abrogate Article 370 after 5 years. Till then, let the Constitution continue. Third, the President is, we recommend that President should modify some of the provisions which we recommend and continue 370 as it is forever. Having done nothing of this, the Constituent Assembly goes without making any recommendation and therefore leaving it to the absolute discretion of the President.
Solicitor, you said that the President is recommendation.
It's a recommendation, my Lord. It's not.
You see the words used in the proviso. Provided that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary.
Yes, Lord. Why I say this, Lord, kindly see the second proviso, where concurrence word is used. Concurrence means I have to say yes, otherwise you cannot do it. Therefore, I am contrasting the word concurrence with recommendation. Consultation, yes, the concurrence is at the highest level. That without consent, concurrence means consent. Consultation may sometimes mean consent, may not mean consent. Your Lordship has seen Justice S.H. Sheth's transfer of judge's judgment, where it says that consultation can even mean concurrence. So I am not just contrasting the word concurrence with recommendation, that the same provision uses the word concurrence, means unless the state say yes, President can do nothing. But here same provision uses the word recommendation, that you will recommend. Ultimate power with the President who is answerable to the House which is answerable to we the people of India. So highest executive functionary is conferred with this decision, and we can read that in absence of Constituent Assembly and its recommendation, the proviso goes. It becomes redundant, it becomes otious, it becomes not possible of being implemented, and law doesn't require performance of an impossibility. But considering the nature of the strategic importance of the state, it was felt necessary that let this be debated in both the houses of Parliament. And Rajya Sabha is, my lord, house of people. It has its own federal structure. Every state has a representation in a different indirect election form. And both houses passes, my lord, with 2/3 majority. My lord, even Constituent Assembly could have recommended that word temporary be deleted. Even clause 3 be deleted. Why not? There was no embargo. During the subsistence, during their existence, and while being dissolved, or during that period, they could have said that delete temporary provision, delete Article 3. Now we don't want anybody's power to abrogate. They could have said even C can be deleted. Suppose, my lord, the Constituent Assembly were to say that delete 1C, that Article 1 is untouchable. Because now we have our own constitution, we no longer are a part of, integral part of India. Lord, it could have said, technically it could have said that. But Section 3 of the Constitution says, no, we are an integral part of India. They never said that President's power under 3, we recommend being either diluted or taken away. They never wanted clause 3 to die. That's very clear.
All right. So we've covered now the first point, the interpretation of 370.
My lord, 370, my lord, there are some points, my lord, if your lordship permits.
So on 370, Mr. Solicitor, why don't you summarize in 3 or 4 propositions what's the heart of your submission?
Can I, my lord, do one thing if your lordship permits? My lord, I knew, my lord, I'll be running against time. My lord, instead of, my lord, my 40-50 pages of, my lord, explanation and arguments, I have summarized in 4 pages.
Right.
That would, my lord, save your lordship's time also in, my lord.
So you have it here?
If I can be permitted, my lord, I'll just quickly go through.
5 minutes and we are done with it.
Yes. You can. Says, my lord, it declares it to be temporary. Your lordships may not read anything, my lord. It is contained in part 21, which has 3 categories: temporary, special provisions, and transitory provisions. So constitutional framers are aware of what word they are using. My lord, second, I have said, my lord, I have already said, and this is, my lord, something very, very serious. Look at the width of the power. 2 individuals in practice, and legally speaking, 2 organs, namely the President and the state government, can alter any part of the Constitution and apply it to one part, can delete any constitutional provision, can create a new provision, and therefore, my lord, the submission is, considering the very expanse of this provision, the constituent framers would never have, my lord, contemplated this to remain forever. Such a position can never remain forever, where our constitution remains a floating document perennially for one state. Then 3. Impact of Article 370 was to deprive the residents of Jammu, Kashmir and Ladakh from being treated at par with their fellow citizens. My lord, therefore, my lord, I am saying that this also is one suggestive indication that framers never intended it to be permanent. Then, my lord, this is the entire provision. My lord, this is very important. This is the entire provision in the Constitution where application of not only Constitution, please see this, my lord, the seriousness of this. Application of Constitution of India and application of central laws, including beneficial legislations, is dependent upon concurrence of the state. The only provision. It says it would not apply, it will not apply. Such a, my lord, drastic provision could never have been intended to remain permanently. Then, my lord, this is the only provision which has an inbuilt self-extinguishing provision, sub-article 3. No other constitution provision has this self-destructing clause. This again, my lord, is a pointer that it was intended to be temporary. Then, my lord, it is a goal of equivalence, my lord, I have already said, my lord, in the judgment which I read, that temporary problem, my lord, provision cannot be read so as to treat one part of state differently, their citizens differently. Then, my lord, your lordships would not give interpretation to a temporary constitutional provision having such drastic consequences. Because your lordships are not going to be confronted with a similar situation in future. There is no other provision in the constitution. And to our knowledge, any other part of the world where a provision of a constitution of the main unit applies only with the state consents. In a federation like ours, there cannot be any such provisions. My lord, then I have said, my lord, kindly examine it from the people's angle. Then 370 is interpreted the way petitioners interpret. 371 would become permanent, which is not only impermissible and not envisaged, but would result in the unconstitutional provision remaining in the constitution and operating. But unconstitutional, why? It discriminates. It confers an authority which is never contemplated in other states. The application of the Constitution of India given by we the people would either not apply fully or would apply. My lord, I am on 10, point number 10. My lord, I would request if your lordships can read with me, my lord. The petitioner's assertion that such a huge decision is taken purely by an executive fiat is absolutely wrong. The process followed clearly reflects participation of entire nation through their chosen representatives, both in Lok Sabha and Rajya Sabha. When a decision becomes concerns a federating unit, it is of strategic significance, what I have pointed out. My lord, then 13, my lord, is most important, my lord. Sub-article 3. The proviso to sub-article 3 was to remain in operation. My lord, I have already said these are the 5 possible recommendations that Constituent Assembly could have given. Your lordships have seen that. Then, my lord, B. Once the Jammu and Kashmir Constituent Assembly ceased to exist, the proviso to Article 370 sub-article 3 itself ceases to exist and the President becomes the sole repository of power under Article 370 sub-article 3, which is coupled with his duty to exercise in the interest of residents of Jammu and Kashmir without any recommendation. It is for this reason that power is conferred upon the highest political executive who is responsible to the Parliament, who in turn is responsible to we the people of India. It is thus clear that Parliament, while framing the proviso, merely gave an option to the Constituent Assembly to make recommendation till its life. But 15 is important. This is how the petitioners want your lordships to read. Notwithstanding anything in the foregoing provisions of this article, on the recommendation of the Constituent Assembly of the state referred to in clause B, the President may, by public notification, declare that this article shall cease to be operative or shall be operative only with such exceptions and modifications. The very purpose that the concept of recommendation is provided in the proviso, Lord, leads to an inevitable conclusion that they wanted it to leave it an option to the Constituent Assembly during its life to make some recommendation. Otherwise, that proviso goes. Lord,
according to you, the proviso will not govern the substantive provision.
Cannot govern. Yes, my lords are right. I am obliged, my lord. If the proviso become OTOs, the main provision does not become OTOs. Then the conditionality attached goes. Tail cannot recognize. Yes, my learned friend is right. If this interpretation to Article 373 is not accepted and the President's power is under Article 373 is taken away merely because the Constituent Assembly has ceased to exist without making any recommendation, it would create a devastating situation which could never have been envisaged by the framers of the Constitution, nor ever been conceived. If the President cannot exercise the powers under Clause 3, it would mean that existence and exercise of power of the President of India provided for in the Constitution is dependent upon some decision or lack of it by a different body. Can we read a Constitution that President's decision is dependent upon some outside body takes a decision or does not take the decision? If it takes, it's an option. If it doesn't take, you lost your option. The President of India cannot be denuded of its power by either they giving recommendation or at least not in absence of recommendation. Such an interpretation would never be given, as such contingency could never have been conceived. Then 17. Secondly, if mere absence of Constituent Assembly mention in the proviso to Clause 3 is treated to be rendering the power of President of India nugatory, redundant and unexercisable, it would mean that by using any provision under Article 371B and 1D, any provision of the Constitution can be amended and applied to the state of Jammu and Kashmir, and even the provisions which are part of basic structure, please mark this, my lord, this is what fell from my Lord Justice call, that you are putting it at the higher threshold than the basic structure. Basic structure cannot be altered by constitutional amendment, but there is no such limitation in 1D. You can, they have chosen not to apply some of the fundamental rights, meaning thereby a permanent power is vested on two organs of the state to alter even the basic structure so far as its application to the state of Jammu and Kashmir is concerned. And this is very, very serious. Now, of course, my lord, it can never be done. Now all are at par. Even if the Constituent Assembly would have been in existence, the limited role stipulated, my lord, that I have already said, my lord, it is only recommendatory, and my lord, President could have taken any other decision.
That may not be correct actually, because so long as the Constituent Assembly, it was not recommendatory. Look at the way the article is couched. Provided that the recommendation of the Constituent Assembly of the state shall be necessary. So it's not recommendatory in that sense.
Our Constitution always, let's put it very, Constitution as a supreme document in a democratic country will always face restriction, whether it's the judiciary, whether it's the president, whether it's the legislature.
Lord, I bow down, but my submission...
Constitution is governance by limitation. And
the use of the words recommendation shall be necessary is a clear indication that it's not merely recommendatory, but that there has to be a recommendation before you exercise.
Can your lordships read it a slight differently, the way, my lord, I read it? What is mandatory, the word shall, that you take recommendation. The recommendation is not binding, my lord. Otherwise, the Constitution would have said that it would and act accordingly. What is mandatory is taking the recommendation. That's another way of, my lord, interpreting.
The other part of the argument, we understand that the proviso, after the Constituent Assembly had done its job, is no longer applicable, but it doesn't affect the main part. We have main clause 3. We'll examine that out.
Yes. Now 19. The only constitutionally compliant way of interpreting Article 370 to achieve the ultimate goal of bringing the people of Jammu and Kashmir at par with the rest of the country and conferring them with all constitutional and statutory rights at par with the rest of the country is to either read an unfettered and plenary power of the President of India under Article 370 sub-Article 3 once the Constituent Assembly ceases to exist. Just now, my lord, I pointed that out. Or modifying the 370 sub-Article 3 by replacing the successor body. We went for the second, which according to me was not necessary. It could have been done without, my lord, any recommendation also. then power of the President under sub-article 3 is unfettered, as Article 370 starts with a non-obstante clause, notwithstanding anything contained in the Constitution of India, and sub-article 3 starts with a non-obstante clause, notwithstanding anything in the foregoing provisions of this article. But kindly see this, something that might throw some light on the first discussion, which my lord, the Chief Justice, very enlightened discussion. Lord, 370 starts with a non-obstante clause. There's nothing in this constitution. This is how the 370 would function. 370 sub-article 3 starts with a non-obstante clause, notwithstanding anything in the foregoing paragraphs. Meaning thereby, even 370 can be subjected to 370 sub-article 3. Kindly read it once again. I do not know.
Obviously, because 370 clause 3 has a non-obstante clause which overrides everything else in this article. Even
1D.
Right.
Even 1D, which says that don't do anything except 1 and 3. And
there are two non-obstante clauses. The first is notwithstanding anything in this constitution. And 370 clause 3 says notwithstanding anything in this article. Therefore, it overrides, therefore, it's a power to override even clause 1.
Clause 1, yes. Clause 1, 2 doesn't come. 1D also. Your Lordship's very illuminating.
But there can't be any doubt about it, because when 370 clause 3 says notwithstanding anything in this article, that would include clause 1. There's no
meaning thereby, modification in 370 itself was permissible through 367.
And when you override clause 1, the plain intent therefore is that the constitution itself becomes applicable then.
Correct.
Once you exercise the power under 3, whether there was a valid exercise is what we have to decide. But once you exercise validly the power under 3, then the constitution applies. That would be the plain consequence of it.
Your Lordship may treat this as read.
Yes, we'll read it. Let's go now to the last point.
Only last
reorganization, Mr.
last 2 pages. Last 2 pages. The status of Constituent Assembly. What was the status of Constituent Assembly? Because nomenclature is a Constituent Assembly. But whether it enjoys, I'm at the outset.
You are saying that it is subordinate to the Constituent Assembly for the Union. I mean, you can't elevate that Constituent Assembly.
I must clarify one thing as an officer of the court. I'm conscious of the principle laid down in Keshwanand Bharti, that there is a distinction between Constituent Assembly and Parliament, or Constituent Assembly and Legislature. They are not interchangeable. That's why, my lord, this submission, that here Constituent Assembly for all intent and purpose was a legislative assembly, not preparing a document of governance for a sovereign region, but was, my lord, kindly similar. There are some arguments based on, my lord, the judgment also, my lord. My lord, the position as far as the state of Jammu and Kashmir is concerned, even prior to coming into force of Article 1, was who created Constituent Assembly? The Maharaja, who signed instrument of accession and surrendered his sovereignty. Then he issued that proclamation. Your Lordships are, my lord, remembering that now whatever constitution is framed would be binding on him. He subsequently, my lord, creates a constituency. So he could never have created a Constituent Assembly which would have a role independent of, larger than, or completely different from the Constituent Assembly of which he became an integral part. And at that time, my lord, the Jammu and Kashmir was an integral part of India. So the body which was created was known as Constituent Assembly, but was a subordinate creature, then, my lord, Constituent Assembly. And the Constitution of Jammu and Kashmir can never be put at the same pedestal as the Constitution of India, because the very birth of the Constituent Assembly of Jammu and Kashmir was because of Article 370. And in
other words, according to you, the role of the Constituent Assembly of Jammu and Kashmir is the role which is created for it by our constitution, by the Constitution of India, nothing beyond that.
It cannot be beyond that, above that, or superior to that. It is subservient and subordinate. It never had original constituent power. Lord, please see, Lord, the constitution as we understand around the world, Lord, has certain attributes, namely, it must be a document of governance, providing for everything, the way, my Lord, we have provided. This constitution has only certain aspects. Rest, my Lord, they leave it to the Constitution of India. For being recognized as a constitution, you must provide for a kind of sovereignty. I'm not on, my Lord, sovereignty means sovereignty, my Lord. It's not autonomy. And sovereignty would mean right to acquire new areas and right to cede new areas, right to acquire territory and right to cede territories, which we have in Article 1, 2, 3, 4. Constitution of India has. Lord, none of the attributes of a constitution, so to say, Lord, can be attached to this constitution. It was a piece of legislature recognized, accepted and known till 5th of August and 6th of August 2019 as constitution. But for all intent and purposes, my Lord, it was, my Lord, even the preamble of the constitution doesn't say so. A preamble of Constitution of Jammu and Kashmir doesn't say so. That this is a document which is a constitution. It merely says, Lord, please see the preamble of Jammu and Kashmir Constitution. It says, with a view to further define our relationship with Union of India. It doesn't say that we are creating a constitution of our governance. Please see, Lord, that's the only purpose. They say, we the people of Jammu and Kashmir, with a view to, I'll just read for your Lordship, my Lord. Lord, I'll just read, my Lord. It is, kindly note the page. Volume 2, page 16. Your Lordship need not open, I'll just read. Even preamble doesn't say that it has attributes of a constitution per se. We, the people of the state of Jammu and Kashmir.
Mr. Solicitor, there is another more fundamental reason why your argument may be correct, which is this. Look at Section 5 of the J&K Constitution. It says the executive and legislative power of the state extends to all matters except those with respect to which Parliament has the power to make laws for the state under the provisions of the Constitution of India. So once the Constitution of India defines which is the area in respect to which Parliament has the power to make laws, then that is denuded from the jurisdiction of the Jammu and Kashmir Legislative Assembly. Now we have seen how progressively the ambit of the legislative domain of Parliament was expanded. For instance, initially the entire concurrent list was outside the power of Parliament.
Correct.
You had only certain entries in list 1, the union list.
I am obliging.
Right? Subsequently, the concurrent list was brought in. Once the concurrent list is brought in within the domain of Parliament, to that extent, the legislative domain of the Jammu and Kashmir Legislative Assembly is denuded. Then entry 97 was wholly outside the purview of Parliament initially. Later on, as we see, entry 97 is also gradually brought in within the purview of Parliament, albeit in the context of laws affecting the sovereignty and integrity of India, terrorism, so on and so forth. Therefore, it's very obvious from Section 5 of the J&K Constitution that once the Constitution of India prescribes a certain legislative domain for Parliament, then that is progressively denuded from the legislative ambit of the J&K Legislative Assembly. And that was not fixed as of 1957. Another very important feature is that Section 5 does not fix the ambit of the legislative or executive domain of the J&K government and the Legislative Assembly as of 26th of January 1957.
Correct.
In fact, it contemplates that what the Constitution of India will prescribe for Parliament will be outside the domain of the
of our domain.
In that sense, it was always intended to be subservient to the Constitution of India.
And my Lord,
it's not really a document which has equivalent effect.
And that's what the 147 makes these provisions unamendable. Section 147, 3 and 5 cannot be amended. Otherwise, what happens? Lord, this is amendable. This constitution, if it would have survived, was amendable by the Legislative Assembly. So, they can amend their preamble and academically, potentially, can become a theocratic state because secularism was not applicable.
All right, Mr. Solicitor, I think we've gone through your Article
Yes.
370 note. Now, what your Constituent Assembly note? Now, what's
Lord,
about?
now, Lord, my
Now you have to deal with the important part about states reorganization and the conversion of
yes, Lord.
the state into a UT. How do you answer that?
Lord, I'll take a little time on this one, not unrealistic time, but there are 3-4 judgments, Lord, which are direct judgments.
All right.
So your lordships would bear in mind the difference between our constitution and, say, Constitution of America, where there is a contract between the state and the federal government, and that is how they form the United States. The federal government doesn't have the power to even alter the boundaries of the states because it's a different and distinct.
There was no contract between the states and the federal government in the US.
Internal.
The 13 colonies came together to form a union, and they surrendered some powers to the union.
To the union, otherwise retaining, my lord, some of the states have its own Supreme Court, etc. My lord, whenever, my lord, a nation like ours and the federalism which we have accepted, which is, my lord, kind of leaning towards unitary feature. I'm not arguing on that unitary versus federalism. But at times, the nation requires to rejudge the boundaries and the status of their states. So there are several considerations. And therefore, at the outset, my lord, I may point out that this is a case, one of its type, which is not to be encountered, my lord, by the court. For example, if Gujarat was to be bifurcated or Madhya Pradesh was to be bifurcated, the parameters would be different. But when Jammu and Kashmir, considering its very strategic importance, border state, history of terrorism, history of infiltrations, history of outside influence, outside means outside the country, etc., etc., there would be several considerations in the mind of the government. We share border with 4 at least countries, all of which may not be friendly, to put it mildly. That's what I say.
Argument based on border states is a problem. We have many states on the border.
No, history also. The history, I have given the details in my affidavit, filed long back, how the situation in Kashmir is developing. The number of deaths of civilians, the number of deaths of security forces, the number of attacks, the number of stone pelting, the number of every week 2 or 3 days of hartal, paralyzing schools, hospitals, banks, business houses, everything. Lord, all these are policy considerations. Lord, whenever a state reorganization takes place, not only there are policy considerations as to why the state needs to be reorganized, but there is always a blueprint as to what the central government would do after the state is reorganized. How to bring, my lord, in a peculiar facts of this case, my lord, the youth in the mainstream, how to ensure that they are gainfully employed, how to float certain schemes so that people on the bordering or who are continuous, facing the attacks of shelling, etc., are now getting a sense of confidence that the government has not left us, etc. There are several considerations that we will have to start with, say, democratic local self-government elections so that the people participate in the internal local self-government institutions for their own good.
The source of the power to reorganize, which is with the Union of India, is the same.
3 and 4.
Right?
parameters would differ.
But therefore, do you concede that power to the union in respect of every Indian state? You're not saying that you should concede that, no, this only exists for J&K, it exists for every Indian state, right?
The power is for all.
Once you concede that power to the union in relation to every Indian state, how do you ensure that, the kind of abuse that they apprehended, we are now not defining it for today, but what we lay down would be the law for the land. It is revised by some larger bench at some point of time. But how do you ensure then that this power will not be
used, my lord, in case of others? My lord, that was my worry. I share your lordship's worry, and therefore, my lord, I started by saying that your lordships are dealing with a one-of-its-kind situation, which is not going to arise, my lord. And if, my lord, I point out, my lord, after...
Not one-of-its-kind situation. We have seen on the northern border, Punjab, very difficult times. Similarly, some states at different times in Northeast, all border states.
One of the states in Northeast presently.
Many
none of
times
them.
As because of whatever reasons, near the border, we can't choose our neighbors, as they often say. We have had problems.
Correct.
So the worry which Chief Justice expresses is that tomorrow, if there is a scenario of order, can each of these states face this problem?
And why each of these states only, my lord? It can happen to, for example, Madhya Pradesh or Gujarat or any state.
Your argument from the borders is what I'm testing. See, there are states which are on border of other countries where situation may not be very palatable. Now, at least those border states, I understood your argument that these border states are category by themselves. How do we distinguish between Jammu and Kashmir and any other border state?
I'll just, my lord, I'm grateful. I'll point out. My lord, in none of the border states, take, my lord, northeastern states or Punjab, as your lordships gave an example.
Uttarakhand has a border state.
Northeastern states or Punjab or any other. Rajasthan has a border, Gujarat has a border.
What possibly is being pointed out, you can't say because it's a border state, so it has to be treated.
I'm not saying it, my lord. That's not the distinction I'm drawing.
Because then it's a very,
my lord, there are several border states: Gujarat, Rajasthan,
Himachal, Uttarakhand.
Himachal. I'm not, my lord. Kindly don't misunderstand my submission that because it is a border state, it requires different treatment. My lord, kindly see the consistent, repeated situation which we are facing since decades on a daily basis is not happening in Gujarat or Northeast or any other border state. Here is a border state where one of our territory is occupied by Pakistan. We have POK. I have given figures. What are the deaths taking place every year, right from 20 years before? This is a problem faced by the nation from decades, since decades, which we are, my lord, trying to, my lord, sort out or deal with. And I'll show, my lord, this is not, my lord, just, these decisions are never taken as knee-jerk reactions. There is always, my lord, policy considerations. Border state, this particular state being a different kind of a border state is one, but there are several considerations. And one of the consideration would be how to bring the youth in the mainstream. And I'll point out, my lord, everything was kept in mind and is implemented. And what we are seeing today is the result of that blueprint being implemented. My lord, after this decision, there were elections which took place of district development councils. There are 34,000 elected people. Democracy going to the grassroots. There are, large number of schemes which are introduced. The youth which used to be employed by the interest not inimical to India, maybe terror groups or whoever, and were paid, now are gainfully employed. Well, there is always a blueprint. And I'll be able to show that blueprint working. Lord, I'm not conscious of the fact that end would not justify the means. But end, your lordships can certainly see whether these policy considerations which decided the reorganization were correct or not. Because the government has acted with a blueprint, not only for reorganization, what would be done after reorganization and how Jammu and Kashmir would return to normalcy. And I'll be able to show the steps which are taken. Right now, my lord, I will deal with in three parts. My lord, the impression which is given to your lordship is that this has been reduced from state to union territory. Means there is a downgradation. And my lord, there are some other factually incorrect statements were made, my lord, by one of the council, my lord, who argued for reorganization, against reorganization, that we lost this, there is no representation, there is no consolidated fund of India, we can't participate in election of president, our seats in the parliament is gone.
Let's look at it at the first level, basic level, textual level of the constitution. Let's go step by step. Then we'll go to the last part, namely, which was what motivated this decision. And there you have said that these are policy considerations. Look at the nature of the state, the history. You can't lose sight of all that. We must also deal with it at a textual level. Does Parliament have the power to convert an existing Indian state into a union territory?
It is.
If it does have that power, how do you read Article 3? If you can just assist us on, that's the basic textual question.
Yes, Lord, there are, my lord, specific judicial pronouncements on.
No, but we will go to the judicial pronouncements.
Why
don't you first look at the text of the statute?
Before that, may I request your lordships to have a just bird's eye view of the Reorganization Act itself? No one has shown that, my lord, to your lordships. I want your lordships to see that.
You look at the Reorganization Act, that will provide us.
I'm not reading every part. I'm just taking your lordship through the titles. Lord, nobody has read.
Lord, and first, that's worrying us. Let's look at the source of the power.
Kindly come to, my lord, Article 3.
Just in a minute or so.
Yes.
Just how you interpret
Article 3. Article 3.
Also, I would like to know whether it's some kind of a, what is the nature of exercise of that power? Is it a permanent exercise of power? Is it a temporary exercise of power? What is
no, it is, my lord, I must, Lord, let me answer that straight. Lord, this question was put in the parliament when the reorganization bill was passed. Lord, I'll just read, my lord, the statement of the honorable minister on the floor of the house.
So the union territory here is not intended to be a permanent territory.
No, my lord.
All right.
And that's what, my lord, I'm making.
Question number two. Number two. How impermanent is it? And question number 3, when are we going to have elections?
I understand, my lord. So that is why, my lord, I was going to show to your lordships the steps taken to ensure that we reach that stage. I will show those steps.
All right. Now let's go to Article 3.
Article 3. Article 3. Formation of new states and alteration of areas, boundaries, or names of existing states. Lord, first, my lord, before that, please read, my lord, explanation 1 so that your lordships can read in that context. In this article, in clause A to E, state includes a union territory, but in the proviso, state does not include a union territory. Correct, my lords?
So wherever you read state, read union territory.
Union territory, except the proviso.
So now let's read clause A in the light of that.
Yes, ma'am. And my lord, this very reorganization has been subjected, and my lord, this honorable court has said that it is permissible. This reorganization act has passed the muster of your lordships under 3 and 4. The judgment I'll show. Parliament may by law form a new state by separation of territory from any state or by uniting 2 or more states or parts of states or by uniting any territory to a part of any state. So, my lord, I would read, Parliament may by law form a new union territory by separation of territory from any state or by uniting two or more states, we are not concerned, or parts of the state, again, we are not concerned. So there is a power of having two union territories out of one state. Then B, increase the area of any state, diminish the area of any state, alter the boundaries of any state. But here, this would also result.
Does clause A contemplate a situation when the entirety of a state can become a union territory?
There are two. Jammu and Kashmir and Ladakh. And there is nothing, my lord, which prohibits.
Does clause A contemplate a situation where an entirety of a state can become, say, more than one union territory? What you have done?
It can, my lord. I'm not answering that question because that doesn't arise here.
Your argument is that because of explanation, we will have to read union territory.
Yes. And in a given case, my lord, I don't want to pitch that high.
The clause A, the problem. Form a new union territory, we will not read it as state. Form a new union territory, singular will include a plural. So form more than one union territory, no problem. Form a new union territory by doing what?
By separation of territory from any state. Territory means geographical area.
Right. So from the state of J&K, you carve out a territory and form, say, a union territory of Ladakh.
Jammu, Kashmir and Ladakh. But I don't want to, my lord, pitch that high. But otherwise, it would not prohibit even a state being made union territory. But that's not the question we are dealing with, my lords.
So the first part of clause A, in other words, according to you, form a new union territory by separation of territory from any state.
And
contemplate a situation where you have a larger state and you contemplate the creation of a union territory by separating out a territory. In this case, you separated out a territory to form the union territory of Ladakh, and then the remaining you carved out and said this will be the union territory of...
It will not amount to reading. Suppose you had not carved out Ladakh and you had declared the whole thing as a UT.
Look, there is no restriction in doing that. I don't wish to pitch it that high.
I'm going to test and understand. Suppose you create one UT only. Then it is form a new state by separation of territory from any state. That has not occurred. No UT has been carved out. Or by uniting two or more states or part of the state, or by uniting any of the territory into part of the state. How will it apply? Suppose you had not carved out Ladakh.
Possibly.
Whole state. So then the power would be the conversion of any state into a UT.
That possibly
the fact that you carve out a part of a state.
Possibly, your lordships are right. That is not
that
is possibly not contemplated, subject to. But form a new state, that is form a new union territory.
That's the proposition.
By separation of territory from any state. So separation is necessary.
So if you don't separate and create, you really, how do you contemplate converting a state into UT? And if, I'm just saying for the sake of argument, if that is not possible, can you do that by carving out a UT and making the other also UT?
There is no restrictions. And this is how, my lord, it is understood by your lordships also. Because, for example, my lord, Assam, Tripura and Arunachal became UT first and thereafter became state. Assam remained a state, that's the distinction. But Assam could have also become a UT. There is no restriction.
That's what I'm saying. See, just carving out Ladakh as a UT is, I would say, less complicated in its nature. So therefore, to test the proposition, I am saying, suppose you don't carve out UT, Ladakh. You decide that the whole state should be a UT. So can you do that and say J&K state will remain as it is as boundary, but from state it becomes a UT? When we want it, we'll reconvert it back to the state.
My lord, my first reading is separation is necessary. That's my first reading.
That is what is a little...
Because that question we are not faced, my lord, right now, in this.
a question will arise to test it that if you cannot convert a state into a UT, then can you carve out a UT? That's fine. But in the bargain, also say that what I could not do without carving out a UT, I can do it now by making both of them the UT.
No, because I had a separate reason to carve out Ladakh as a separate UT.
You may. No difficulty. That's your decision. That's why I'm saying this less complicated
Yes.
by its nature. Carving out a UT.
Here it's less complicated.
Reducing both parts of the carved out and the pre-carved out. So suppose Assam, you carved out a UT. But you say no, we carve out a portion of the Assam as UT and also convert Assam into a UT. That's the testing proposition.
It would be an extreme example, but for the purpose of testing, there can be two answers. A, separation would be necessary, and if separation takes place, that doesn't take place if one state is declared UT. So one state cannot be declared.
What is troubling me? Whether
Your Lordships are right. One state possibly, under 3 cannot be declared as UT. But here, it is nobody's case that we declared Ladakh as UT to come out of this embargo. It's nobody's case. We had separate reasons.
Mr. Solicitor, there may be another way of looking at it. Apropos the theme with which you began, which was the general situation in Jammu and Kashmir. As we see, the creation of union territories post-independence, you have on the one hand examples like Chandigarh, which was carved out during the Punjab Reorganization Act and remained a union territory. It is a permanent union territory.
It was a part of state.
It was a part of a state and became a union territory to be the common capital for 2 sister states. That one. Then you have a progression where certain areas of existing states became union territories in the progression of making them states. That's the Northeast. For instance, you have Mizoram, you have Manipur, you have Tripura. They were part of states. They become union territories, but that's in the process of making them into a stable administration to become states. You can't immediately make them states. Parliament can certainly make that. Today, the situation is not right to make them full-fledged states. Today, we will carve them out, give them the status of a union territory at a future point of time when Parliament feels that, well, they now are sufficiently stable institutionally, we will make them as states, which we did in the Northeast. To put something, perhaps you may look at what we are trying to suggest. Why is it not possible for the union to say that, well, right now, say in a case of a particular state, we have such an extreme situation in terms of national security, in terms of, other...
we want direct control.
That we want for a certain stipulated period that a union territory should be created. But this creation of a union territory is not a feature of permanence. But this shall then again progress back to its position of a state.
Removing the reasons why it was required to be converted.
The union not have a control for a certain stipulated period to bring stability, because ultimately, let's face it, whether it's a state, whether it's a union territory, all of us have survived, the nation survives.
Yes.
Right?
Doubtlessly.
The nation itself doesn't survive, there's no question, there's no relevance of states or union territories. So is it not should we not give that allowance to Parliament to sort of postulate that for a certain period, in the interest of the preservation of the nation itself, in the interest of the preservation of the union itself, we want for a certain stipulated period that this particular state should go into the fold of union territory on the clear understanding that this shall revert to a position of a state over a period of time. You can't lay down that period in a given case. In a given case, it may be 6 months. In a given case, it may be 1 year. But that progression, I think the government has to also make a statement before us.
Look,
that progression back to a state has to take place. It can't be a union territory in permanence.
I'm grateful, my lord. That's exactly, I'll read, my lord, after the lunch. That's exactly the statement made on the floor of the House. I'll read, my lord, their statement. That this is not a permanent feature. After the situation returns to normalcy, we want it to become a state again. I'll read, my lord, that statement.
And then after lunch, we would also have we don't want to bind you down to because we are conscious of the fact that these are matters of national security. We understand that, ultimately the preservation of the nation itself is the overriding concern. But without putting you in a sense of a bind, both you and attorney may seek instructions at the highest level. Is there some time frame in view?
No, time frame. I'll take instructions once fallen from your lordships, but I'll show the statement made on the floor and the efforts made. And the statement is, once the efforts are fruitful and everything is normal, then, my lord, there is a. But I'll
equally, Mr. Solicitor and Mr. Attorney, restoration of democracy is a very important.
Absolutely,
it's a vital component for our nation.
In 2020,
a situation where you have.
My lord, only one thing. My lord, give me a second more. In 2020, for the first time in the history, the local government elections took place. 34,000 people are now elected people, which is possible only because of.
Therefore, the progression, we take your point. We take your point that the progression has already begun.
Yes, madam. No hartal, no stone pelting, no curfew. At least situation is normal, my lord.
But
no, I am not only on, my lord, election and politics. I am on, my lord, national integrity. My lord.
Is there a roadmap?
Yes, yes, it is.
And tell us what the roadmap is.
Apropos, my lord, what fell from your lordships before the lunch break, Lord, I have taken instructions, my lord, hurried. Lord, the instructions are that UT is not a permanent feature. But I'll make a positive statement, my lord, tomorrow, that is day after. Because I'll have to meet, my lord.
For Kashmir, Jammu and Kashmir.
Yes. Yes, my lord. Not
Ladakh.
Ladakh. Ladakh would remain UT, my lord. That's what we have understood, my lord. But we'll meet personally, my lord, AG and me, and we will make a statement. But I must tell your lordships, my lord, so far as Ladakh, as my lord, I have already pointed out that local body in terms of district development council elections took place in 2020. And so far as Ladakh is concerned, it consists of two units. Units, my lord, is a loose word I am using. That is Leh and Kargil. Lord, election to Ladakh Autonomous Hill Development Council, Leh, is held in October 2020 for 26 seats. And for Kargil, it is going to be held on 10th of September 23. So, Ladakh election would be over. But I may, my lord, your lordships need not open, my lord. It is volume 10, document compilation volume, page 763.
Document compilation volume?
Volume 10, page 763. But I am reading 4 lines from Lok Sabha and 4 lines from Rajya Sabha, because something said on the floor of the house has its own sanctity. Therefore, my lord, I am reading it. Lord, your lordship says, my lord, page 763, my lord, volume 10. Because the Honorable Home Minister introduced the bill and it was debated. It was debated for both the days.
This is Lok Sabha, this one?
This is Lok Sabha, my lord. What I am reading at page 763 is Lok Sabha. All members participated in the debate and my lord, relevant is the last para. अध्यक्ष महोदय, मैं अनुच्छेद 370 की बात बाद में करूंगा. सबसे पहले मैं इस चर्चा में काफी सारे सदस्यों ने भाग लेते हुए कुछ चीजों के बारे में जानना चाहा है, कुछ मुद्दे भी उपस्थित किए हैं जिनका मैं सबसे पहले जवाब देना चाहूंगा. काफी सारे विपक्ष के सदस्यों ने कहा है, सम्मानीय सदस्यों ने कहा है कि यूटी क्या हमेशा के लिए है, यूटी क्यों बनाई गई है, यूटी कब तक रहेगी. सोएन ने भी कहा. मैं इस सदन के माध्यम से पूरे देश के सामने और विशेषकर घाटी और जम्मू, घाटी मीन्स वैली के लोगों के सामने स्पष्ट करना चाहता हूं कि जहां तक यूटी का सवाल है, परिस्थिति सामान्य होते ही उचित समय पर पूर्ण राज्य का दर्जा देने में इस सरकार को कोई आपत्ति नहीं है.
It's just read the last 3 words again. Is it say पूर्ण राज्य?
पूर्ण राज्य का दर्जा. I'll just read. मैं इस सदन के माध्यम
full state.
मैं इस सदन के माध्यम से पूरे देश के सामने और विशेषकर घाटी और जम्मू के लोगों के सामने स्पष्ट करना चाहता हूं कि जहां तक यूटी का सवाल है, परिस्थिति सामान्य होते ही उचित समय पर पूर्ण राज्य का दर्जा देने में इस सरकार को कोई आपत्ति नहीं है. Then, my lord, 512 is Rajya Sabha, my lord. There also, my lord, this question arose. Lord, somewhere 10th line from the top, my lord, it starts with कई माननीय सदस्यों. But I'm on page 162. I'm sorry, page 512. Your lordship has one. My lord,
After that, after the English words, constitutional position?
उससे द सेम लाइन, अगर सभापति महोदय की आज्ञा हो तो मैं पूरी कॉन्स्टिट्यूशनल पोजीशन सदन के सामने रखने को तैयार हूं। एक माननीय सदस्य ने पूछा कि कब तक यह यूटी रहेगा। मैं माननीय श्री सोएनसो और जिन अन्य माननीय सदस्यों ने यूटी के बनने पर आपत्ति दर्ज की है, मैं निश्चित रूप से उनको आश्वस्त करना चाहता हूं कि जैसे ही नॉर्मल परिस्थिति हो जाएगी, उचित समय आएगा, इसको फिर से स्टेट बनाने में हमें कोई एतराज नहीं। मैं आज इस सदन के माध्यम से जम्मू कश्मीर की जनता को भी कहना चाहता हूं कि जम्मू कश्मीर भारत का मुकुटमणि है और इसमें कोई मतभेद नहीं है। जब भी उचित समय आएगा, मगर आज जिस प्रकार के भाषण हो रहे थे, मुझे लगता है थोड़ा लंबा समय रहेगा, एटसेट्रा एटसेट्रा, क्योंकि इस भाषण इसके बाद घाटी में भी होने वाले हैं। दैट वाज माय लॉर्ड एन एप्रीहेंशन।
What's the date of this?
5th of August 2019, when reorganization bill was being considered. May I quickly, my lord, take your lordships through the judgments, my lord, on Article 3, 4, whichever way, my lord, your lordships would like me to go. I'll read, my lord, only cite few judgments on reorganization and 356.
All right. Where are they, Solicitor?
Yes. My lord, 162. My lord, your lordships have read
compilation.
My written submission, volume 3, combined written submission. My lords have seen Article 3 and Article 4. The respectful submission is, my lord, and this, my lord, we, during discussion with Mr. Trivedi, my lord, we came to know, Lord, the distinction is, this is the only state where it was not at par with the rest of the country, and now it is becoming the part. That is, my lord, the distinguishing feature which would never arise in case of any other state. Now, my lord, this UT, my lord, of Jammu and Kashmir came up for consideration of this honorable court. My lord, at page 162, the judgment of...
I closed the compilation volume, so I'll have to research find out where...
Volume 3.
I'm sorry?
Volume 3. Volume 3.
Which you are reading.
Yeah.
My written submissions. But what I've done is, so that your lordships may not have to shuffle through the judgment volumes, I have quoted the paragraphs I am relying upon, verbatim.
This para 85 onwards?
Yes, madam. No, madam. Para 85 onwards, yes, madam. I'm skipping the paragraphs. I'm just reading the judgments.
I'm just locating, I have the page, that's all.
Yes, yes.
Right.
I'll read the judgments, my lord.
First,
Your lordship, I have noted the judgment of this court, my lord, in case of Jammu Kashmir. The present reorganization. Article 3 provides that Parliament may by law form new states and alter the area's boundaries.
Para 89.
I'm sorry.
Para 89.
Para 89. I'm sorry. May I read?
Yes.
Article 3 provides that Parliament may by law form new states and alter the area's boundaries or names of the existing states. The explanation 1 provides that in clauses A to E of Article 3, a state includes union territory. Thus, explanation 1 makes it amply clear that the power of Parliament under clause A of Article 3 to make a law to form a new state or to alter a boundary of a state includes a power to make a law to form a new union territory. Explanation 2 clarifies that power conferred by clause A on Parliament to enact the law to frame a new state includes a power to form union territory by uniting parts of any state or union territory to any other state or union territory. Not kindly come to para 26, my lord, at page 163. On conjoint reading of Article 3, 4 and 239A, we find that Parliament, by making a law, can convert an existing state into one or more union territories. B. Parliament is empowered by law to create a body of legislature for the union territories of Puducherry and Jammu and Kashmir. Accordingly, subsection 2 of section 14 of Jammu and Kashmir Reorganization Act provides that there shall be a legislative assembly for union territory of Jammu and Kashmir. And C. Even if law made by Parliament creating a body of legislature for union territories of Puducherry and J&K has the effect of amending certain parts of the Constitution, it shall not be deemed to be an amendment of the Constitution for the purpose. But if your Lordship sees holistically Article 3 and Article 4, and I am saying this academically, I am not pitching it, my lord, for this particular case. But there is nothing, if we read as a common scheme of, my lord, reorganization, that one state, for a good reason, the threshold of your lordship's satisfaction would be higher, can be converted into union. Because 4 says some incidental provisions can even include something which may otherwise amount to amendment, but would not be treated as an amendment under 368. Then, my lord, Pradeep Chaudhary, my lord, I'm skipping at your lordship's.
1 and 2 were made applicable to Jammu and Kashmir. No?
Yes, what happened was, during the first arguments of the petitioners, they pointed out the Article 3 as applicable to the state of Jammu and Kashmir, which provided that nothing can be done without consent of Jammu and Kashmir Assembly. Without pointing out to your lordships that before this Reorganization Act was placed before the House, the entire Constitution was made applicable. Therefore, that proviso goes. Now, what Article 3 your lordships have applied, my lord, when this reorganization took place. Lord, I hope I am able to make myself clear. What was shown was the earlier Constitution as applicable to Jammu and Kashmir, Article 3 as applicable to Jammu and Kashmir, which provided for a mandatory consent. But first, the President issued 272, CO 272, applied the whole Constitution, meaning thereby what we are reading now as Article 3 was Article 3 when reorganization took place.
What's the date of reorganization? What's the date of reorganization?
It was passed on 6th of August. In both houses. Lord, this is, Berubari is considered. Lord, Berubari, your lordships are aware, my lord, has no application. A part of India was being ceded to some other country. That was the concept. That was the fact situation arising in Berubari. There was a mistake in Berubari, which 5-judge bench in Ramkishore notes and corrects. And thereafter, there is an amendment to the Constitution, knowing that now there was a mistake in Berubari. I'll show, my lord. Please come to para 91 at page 164. Only, my lord, the relevant parts I have quoted and I'll read. This is a 5-judge bench, my lord, speaking to my Lord Justice Gajendra Gadkar. Before proceeding to deal with the points which have been raised before us by Mr. Mukherjee on behalf of the appellants, it is necessary to advert to the opinion expressed by this court in re the Berubari Union and Exchange and Enclaves, so-and-so. The Berubari Union at para so-and-so, with a view to correct an error which has crept into the opinion through inadvertence. On that occasion, it was urged on behalf of the Union of India that if any legislative action is held to be necessary for implementation of Indo-Pakistan Agreement, a law of Parliament relating to Article 3 of the Constitution would be sufficient for the purpose, and that it would not be necessary to take any action under Article 368. This argument was rejected. In dealing with this contention, it was observed by this court that the power to acquire new territory and the power to cede a part of the national territory were outside the scope of Article 3C of the Constitution of India. This court then took the view that both the powers were essential attributes of sovereignty and vested in India as an independent sovereign republic. While discussing the significance of the several clauses of Article 3 in that behalf, it seems to have been assumed that union territories were outside the purview of the said provisions. In other words, the opinion proceeded on the basis that the word state used in all the said clauses of Article 3 did not include the union territories specified in the first schedule. Apparently, this assumption was based on the distinction made between the two categories of territories by Article 1(3). In doing so, however, the relevant provisions of the General Clauses Act were inadvertently not taken into account. Under Section 358B of the said Act, state, as respects any period after the commencement of the Constitution, 7th Amendment Act, shall mean a state as specified in the first schedule to the Constitution and shall include a union territory. This provision of General Clauses Act has to be taken into account in interpreting the word state in the respect of clauses of Article 3, because Article 367(1) specifically provides that unless the context otherwise requires, the General Clauses Act shall, subject to any adaptations and modifications that may be made therein, under 372, apply for the interpretation of this Constitution as it applies for interpretation of an act of legislature. Therefore, the assumption made in the opinion that Article 3 in its several clauses does not include union territory is misconceived, and to that extent, the incidental reason given in support of the main conclusion is not justified. My Lord, after this judgment, my Lord, 18th Constitution Amendment is made. Judgment is, my Lord, 27th August 66. I'm sorry, the judgment is 1965.
What is the date in 1965?
Lord, I'll just give the Lordship may give me a minute. The amendment is, my Lord, 27th August 68.
27th August?
66. 27th August 66.
And just give us Ramkishore's.
By which, my Lord, these explanations came to be added.
Right.
That state includes UT. That was, my Lord, result of this Ramkishore Sen judgment. My Lord, if your Lordship would like to see where it is PDF volume 6, case compilation volume 6.
For what? Ramkishore judgment.
Ramkishore judgment. Your Lordship wanted Ramkishore judgment?
Yes, sir, just the date. Just give us the date, that's all.
My Lord, 11th August 1965.
All right.
This is prior to...
Now, your Lordship, my Lord, kindly directly go to Lord, your Lordships have seen page 167, the view of Justice Khanna, my Lord, Justice Khanna, Delhi High Court. And thereafter, my Lord, I'll read Mangal Singh little later because it's not, my Lord, quoted here. Please come to 169, page 169. State of West Bengal. And read only the highlighted part. Now, my Lord, I am confining to highlighted part. My Lord, your Lordship, only, my Lord, note, my Lord, there is some typo. 1964 1 SCR, page number is not mentioned, my Lord, 371. You can correct. Page 169, citation. 371. May I answer? Look, this is a judgment by 6 honorable judges bench. The legal sovereignty of Indian nation. Your Lordship, guess, my Lord, Justice call, my Lord, para 101.
101.
The judgment is, my lord, State of West Bengal versus Union of India.
Yes.
Legal sovereignty of the Indian nation is vested in the people of India, who, as stated by the preamble, have solemnly resolved to constitute India into a sovereign democratic republic for the object specified therein. The political sovereignty is distributed between, as well as we will presently demonstrate, the Union of India and the states with greater weightage in favor of union. Kindly come down, my lord, to para 35 of the judgment, only the underlying portion. There are no independent constitutions of the states apart from the National Constitution of Union of India. Chapter 2, Part 6, from Article 152 to 237 deals with states, the power of legislature of the states, the power of executive and judiciary. What appears to militate against the theory regarding the sovereignty of the state is the wide power with which the Parliament is invested to alter the boundaries of states and even to extinguish the existence of a state. There is no constitutional guarantee against alteration of boundaries of the state. By Article 2 of the Constitution, the Parliament may admit into the Union or establish new states on such terms and conditions as it thinks fit. And by Article 3, the Parliament is by law authorized to form a new state by redistribution of territory of a state, or by uniting two or more states or parts of states, or by uniting any territory to a part of the state, increase the area of any state, diminish, etc. But then 4 lines from thereafter, Parliament. The word starts with Parliament. Parliament is therefore by law invested with authority to alter the boundaries of any state and to diminish its area so as even to destroy a state with all its power and authority. That being the extent of the power of Parliament, it would be difficult to hold that the Parliament which is competent to destroy a state is, on account of some assumption as to absolute sovereignty of the state, incompetent effectively to acquire by legislation designed for the purpose of property owned by the state for government purposes. Then next is, my lord, again, Babulal Parate is 5 judgment. For Babulal Parate, this is different, my lord, not that 19(1)A judgment. That is also Babulal Parate, my lords, recollect, my lord, freedom of speech and expression. Lord, here, views, my lord, the assembly's views were taken from Bombay Assembly for ABCDE areas. And when the Reorganization Act, Act was passed, Lord, it was some additional areas were also, Lord, therefore that was under challenge. We proceed now to consider these contentions. It is necessary to state at the outset that our task is to determine on a proper construction the true scope and effect of Article 3 of the Constitution with particular reference to second condition laid down by the proviso thereto. We bring it to our task such consideration as are germane to the interpretation of an organic instrument like the Constitution, but it will be improper to import into the question of construction doctrine of democratic theory and practice obtaining in other countries unrelated to the tenor, scheme and words of the provision which we have to construe. Lord, kindly come to the later part, my lord. Article 1 of our Constitution, Lord, somewhere in the 10th line from bottom of 170. Does your lordships get me?
Yes.
Article 1 of our Constitution says that India is a union of states and the territories thereof are specified in the schedule. There is therefore no difficulty in understanding what it meant by expression state in Article 3. It obviously refers to states in the first schedule, and the legislature of state refers to the legislature which each has under Constitution. That being the position, we see no reason for importing into the construction of Article 3 any doctrine, consideration of the sanctity of rights of states, or even for giving an extended meaning to the expression state occurring therein. None of the constituent units of Indian Union was sovereign and independent in the sense the American colonies or Swiss cantons were before they formed their federal unions. The Constituent Assembly of India, deriving its power from the sovereign people, was unfettered by any previous commitment in evolving a constitutional pattern suitable to the genius and requirement of the Indian people as a whole. Unlike some other federal legislatures, Parliament, representing the people of India as a whole, has been vested with the exclusive power of admitting or establishing new states, increasing or diminishing the area of an existing state, or altering its boundaries, the legislature or legislatures of the states concerned having only the right to an expression of views on the proposals. It is significant that for making such territorial adjustment, it is not necessary even to invoke the provisions governing constitutional amendments. Then, my Lord, Raja Rampal, only one line, my Lord, I'll now coming down to one line, my Lord, kindly, my Lord, appreciate. It says India is an indestructible union of destructible units. Raja Rampal, my Lord, again, 5-judge bench. Law, my Lord, I am pointing out. I am not pitching that argument that high, my Lord. What we have done is, as a temporary measure, as it is clear from day one, the parliamentary debates, that we have created two units, namely two union territories, and one union territory is with legislature, the power vested with the power of police with the center. Because of the very peculiar nature of the situation arising since decades. Rest everything they have, what state has.
Pointed out two instances where it has happened. First was Punjab. That was a very peculiar problem. Punjabi Suba movement, etc. More or less everybody was agreeable. Probably it could not muster through the legislative assembly.
No, there was no assembly. It was during governor's rule.
No, I understand that, but earlier it could not muster through the division of Punjab between Haryana and then parts of Punjab going to a union territory first, even in Himachal Pradesh, then Himachal Pradesh itself becoming a state. And then probably Cochin and Travancore is the other example which is given. The third is this. This is a way, because once you suspend the proviso, and virtually the power of the state governments are taken away. The representation of the state is represented by the will of the people of the larger country.
Correct.
Can lead to...
That is, my Lord, touched upon in Bomai, S.R. Bomai. My Lord, please come to page 173. Even this question was, my Lord, considered in Bomai judgment. We read Bomai judgment for a different issue. But this was also one of the considerations, one of the factors which fell for consideration of the court. Page 173. Where the court considers what is the scope and ambit of the state's views. That's why I'll, my Lord, rather than paraphrasing, I'll read, my Lord. Lord, kindly see SR Bromide, para 108. Lord, para 108, my Lord Justice, call page 173. I have quoted SR Bromide. Lord, last 4 lines on that para. But I'm trying to rush, my Lord, so that I can finish. Your Lordship gets on a conjoint reading, my Lord. My Lord Justice Khanna gets on a my Lord Justice Suryakant and yes. On a conjoint reading of these articles, it becomes clear that Parliament has the right to form new states, alter existing states, or the name of any existing state. Thus, the Constitution permits changes in the territorial limits of the states and does not guarantee their territorial integrity. Even names can be changed. Under Article 2, it is left to Parliament to determine the terms and conditions on which it may admit any area into the Union or establish new states. In doing so, it has not to seek the concurrence of the state whose area, boundary, or name is likely to be affected by the people. All that the proviso to Article 3 requires is that such cases the President shall refer the bill to the legislature of the states concerned, likely to be affected, to express their views. Once the views of the states are known, it is left to Parliament to decide on the proposed changes. Please, my Lord, note, Parliament can, therefore, without the concurrence of the states or states concerned, change the boundaries of the state or increase or diminish its areas or change its name. These provisions show that in the matter of constitution of states, Parliament is paramount. This scheme substantially differs from the federal setup established in the United States of America. So, my Lord, it is in substance, in my respectful submission, said that it's a provision which is strict compliance is not insisted upon, provided there is a broader compliance, namely the entire nation, considering that this affects the nation as a whole. This situation doesn't affect the state only or neighboring states only. This affects the entire nation and therefore including representatives of Jammu and Kashmir. Parliament and Rajya Sabha, Lok Sabha and Rajya Sabha have representatives of Jammu and Kashmir. So, these are my judgments on 3 and 4. Would your Lordships like to have a bird's eye view of the Act?
All right.
Lord, Volume 3, documents, page 112. I won't take more than, my Lord, 5 minutes to do this. I am, my Lord, tempted to show this because nobody has shown, which could not have been my objection, but without showing several statements were made that we are reduced to nothing, everything is taken up. Therefore, my Lord, it is my duty to point out just bird's eye view, my Lord. Page 112.
Volume 3.
Volume 3, document volume 3, my Lords. Page 112. Lord, please see definition, assembly constituency is defined 2C. It has all attributes of a state. It is state with UT with legislature, but all attributes of a state. Assembly constituency, your Lordship gets 2C. Am I with your Lordship? Yes. Then election commission 2D. Then 2G, my Lord, on the next page, 113. 2G, legislative assembly. J, population ratio and union territory. Please, my Lord, see the formation of union territory of Ladakh without legislature. Then, my Lord, formation of union territory of Jammu and Kashmir with legislature. Correct, my Lords? Then come to, my Lord, page 114. No reduction. They say that our representation in Parliament is reduced. On and para 10. On and from the appointed date, there shall be allocated 5 seats to successor Union Territory of Jammu and Kashmir and 1 seat to Union Territory of Ladakh in the House of People. Earlier they had 6. Now it is 5 plus 1, 6. Then delimitation of I'm sorry.
That's section 10.
Section 10, my Lords. My Lord, the argument of Mr. C.U. Singh was that we have lost representation in Parliament. Then somebody said that our seats are reduced. Lord, Mr. Nafde said the seats are reduced. It was 6 in total. Now it is 5 Jammu and Kashmir and 1 Ladakh. In Malot 12, every sitting member of the House of People representing a constituency which, on the appointed day by virtue of the provisions of Section 10, stands allotted, with or without alteration of boundaries, to the successor Union Territory of Jammu and Kashmir or Union Territory of Ladakh, as the case may be, shall be deemed to have been elected to the House of People by that constituency as so allotted. So they continue as Lord Lok Sabha members. Then 13, all and from the appointed day, the provisions contained in Article 239A, which are applicable to Union Territory of Puducherry, shall also apply to the Union Territory of Jammu and Kashmir. So, my lord, now, my lord, this is amended. My lord, this is amended. What is placed is not amendment. Lord, I'll just place your lordship, Lord, the copies of the amended act. I'm not reading from this act, Lord, I'll give copies to the other side also. Because this has all the acts which are made applicable, which were not applicable, central acts, including beneficial legislation. And suitable amendments in the local acts. Local acts are retained if they are not repugnant to the central acts, with suitable modifications making them constitution compliant. Well, this is amended, section 13, because the argument was that now we can't vote. MLAs of Jammu and Kashmir cannot vote. Lord, at page 10, foot of the page, section 13. My Lord Justice Gawai and Justice Suryakant has that. Page 10 of this book, my Lord. Amendment is in this book, therefore, my Lord, I'm. Page 10, right side, left side, top is the pagination. Section 13. On and from the appointed date, the provisions contained in Article 239A or any other article containing reference to elected members of the Legislative Assembly of the state, which are applicable to Union Territory of Puducherry, shall also apply to Union Territory of Jammu and Kashmir. So they can vote, my Lord, wherever MLA is required to vote. For example, the example given by petitioner was presidential election. Then 14, my Lords. I have one copies. Section 14. There shall be an administrator appointed under Article 239A of the Constitution for the Union Territory of Jammu and Kashmir, and shall be designated as Lieutenant Governor. The total number of seats in the Legislative Assembly would be 107. Then, my Lord, every entry except police. Police is, my Lord, now for obvious reasons, my Lord, I need not even explain why police is, my Lord, directly under the control of the center. My Lord. And clause 6, my Lord, this comes for the first time. 14.6. This was never there. Seats shall be reserved for scheduled caste and scheduled tribes in the Legislative Assembly of the Union Territory of Jammu and Kashmir. This has come for the first time. Then come to, my Lord, section 16. Lord, earlier only permanent residents could contest elections under section 16. I'm not inviting your lordship's attention to read it. Now, he should be a citizen of India. He need not be a permanent resident for being qualified to be elected, my lord, like any other state, my lord. My lord, please come to the relevant entry, my lord, the relevant section, my lord, is at page 119, bottom, section 32, extent of legislative power. Lord, subject to my answering your lordships about the election on, my lord, day after, when, my lord, in the morning. But
119 of your compilation or?
no, my lord, the act. That's volume 3, my lord, same act. I'm reading from the act, my lord. Page 119, section 32. Volume 3, document volume 3, my lord. Your lordships have 32. Subject to the provisions of this act, the Legislative Assembly may make laws for the whole or any part of the Union Territory of Jammu and Kashmir with respect to any of the matters enumerated in state list, except the subjects mentioned at entry 1 and 2, namely public order and police, respectively, or the concurrent list in the 7th schedule to the Constitution, insofar as any such matter is applicable in relation to Union territories. Then, my lord, 35, inconsistency between the laws, my lord, there is a provision. Special provision as to finance.
Follows the Delhi model. Delhi model.
Has land.
Delhi, of course, 1 and land. 1, 2 and 18 is carved out. Land is given to the state legislation.
No, land is not given.
Not given. Where is land accepted? Which provisions is land taken away?
Not here, not here. Here only police and public order.
Right.
Lord, in Delhi.
I thought you were saying land is also taken away.
No. In Delhi, it is public order, police.
And 1, 2 and 18.
1, 2 and 18. Your lordships, Lord, we have troubled your lordships for a long period, my lord, on that. I wanted to avoid that part, my lord, but it is.
It's argued so many times that even 1, 2 and 18 is stuck like a mantra in the brain, you know. So.
Yes. But here, my lord, 18 is not there, my lord. It is only public order and police.
Yeah, public order and police.
And for, my lord, reasons obvious. The very object and purpose of reorganization is this. My lord, thereafter, there are financial bills provisions.
One more change. Parliament has competence on all the 3 lists.
That is because of 239AA. My lord, not here, it's not there.
So unlike a state legislature, in the case of union territories, like Delhi, for instance, Parliament can enact a legislation on any item.
No, that is because of 239AA.
Okay. But
here,
I'm saying the same principle is followed here.
I don't think, my lord.
It is.
Subsection
Here, 239.
Subsection 2, nothing in subsection 1 shall derogate from the powers conferred on Parliament by the Constitution to make
Yes.
respect to any matter for the union
So, my
territory.
lord, that 239AA provision is incorporated in the statute. Your lordships are right. My lord, there is a consolidation for consolidated fund, my lord, which Mr. C.U. Singh said it's taken away. Annual financial statements, audit by the CAG. My lord, this is an official language, my lord. For the first time, there is an official language, my lord. I wish this was pointed out to your lordships, my lord, while saying that we have been deprived of everything. It's just a UT. It is a state, my lord, for all purposes except these 2 entries. I'm not going into the minute details, my lord, but it's a. Lord, Mr. C.U. Singh argued that the assets are also merged with Union of India.
Actually, nothing turns on it in this case. It's almost like trivia right now. But clause 2 says nothing in subsection 1 32, shall derogate from the powers conferred on Parliament by the Constitution to make laws with respect to any matter for the Union Territory of Jammu and Kashmir or any part thereof. So this provision does not empower Parliament to make a law on the state list.
Like 239 AA.
The provision comes in 246(4). 246(4) says Parliament has power to make laws with respect to any matter for any part of the territory of India not included in a state, notwithstanding that such matter is a matter enumerated in the state list.
No, that is at par with everyone.
That's why, no, just as a matter of constitutional position, Parliament can enact a law on all the three lists for Jammu and Kashmir.
Even in absence of subsection 2, it could have.
That's right. That's Article 246(4).
Constitution operates.
That's a constitutional position.
So I am not reading, my lord. Mr. C.U. Singh, my lord, said that even the assets will go to, has gone to the central government. So there is a specific provision, apportionment of assets. Jammu and Kashmir assets remain with Jammu and Kashmir, and Ladakh assets went to Ladakh. That's how, my lord, whenever reorganization takes place, the things happen. Now, my lord, I may come to Article 356. But kindly come to my written submissions, and this is, my lord, the last part of my submissions, my lord. I have already crossed my time, my lord, but 142. Yes, my lord, I am placing it for your lordship's consideration. Lord, the government's rule, governor's rule is in challenge, as I have pointed out, after 14 months.
Which PDF?
142, my lord. My written submissions, 142. Volume 3, 142. Your lordships have a chart, my lords?
Yes.
So what I have done is, I have mentioned the number of the petition with the name, prayer prayed for, and the grounds for challenging this proclamation. These are the only petitions and these are the only grounds in those petitions. The lordships are aware, my lord, how a constitutional act of imposition of governor's rule or president's rule is to be challenged, and what should be the averments. What was the material, sufficiency, this, that, another? Nothing, because it was done after 14 months. Only as a corollary of challenging 5th and 6th of August action. I am not reading, my lord, the pleadings, but there are no pleadings. My lord, that's all I am saying. Lord, now, Lord, I am not reading, but there are no pleadings that it is arbitrary, it is illegal, and therefore declare it to be a void. That's all, but nothing, no pleadings. Only technically a prayer is there. That's what, my lord, they can argue. Therefore, they have made a prayer after 14 months without pleadings. Now, please come to, my lord, 146 of this very note, my lords. On the question, so this is again S.R. Bomai. I am on page 147. But I am going fast. I have seen your lordship's eyes looking at the clock, my lord. I am also on the clock.
No, that's not. Please don't have any such feeling.
On the lighter side, but it's
that eye goes to the clock just as a matter of training. That's all.
On the lighter side, what I am saying, so that
not directed to that one, you also.
More than 22 years of training on this.
Exactly, more than 22 years of training. Mr. Solicitor, when we were judges of the Bombay High Court, we had a colleague who who had come from Gujarat on transfer, a God's good person. So he had this specialization. We would meet outside the Chief Justice's chamber every morning. Just a little bit of camaraderie, and then we go to So every day, our colleague who had come from Gujarat would tell us how many more days there are to go back to the vacation.
Yes.
So,
But it is said that
66 days left for the vacation.
but it is like many other parts, but it is said that a Gujarati can come out of Gujarat. Gujarat never comes out of him. we always. But 146, last part, only underlying portion. 147. Bomai, SR Bomai. So this, my lord, kindly read, my lord, the canvas of the court's jurisdiction. In fact, once the issuance of proclamation is held valid, the scrutiny of the kind and degree of power used under the proclamation falls in a narrower compass. There is every risk and fear of the court undertaking upon itself the task of evaluating with fine scales and through its own lenses the comparative merits of one rather than the other measure. The court will thus travel unwittingly into the political arena and subject itself more readily to the charges of encroaching upon the policy making. The political thicket objections sticks more easily in such circumstances, although therefore on the language of Article 356(1), it is legal to hold that the President may exercise only some of the powers given to him. In practice, it may not always be easy to demonstrate the excessive use of power. Lord, why I am reading this, Mr. Sibal read the first part of it. Lord, his attention, my Lord, missed this last part. My Lord. Therefore, I am for completion. This is the law. My Lord. Lord, kindly come to the next judgment, my Lord, at page 148, State of Rajasthan versus Union of India. Lord, 7 honorable judges, my Lord. Lord, the bold part, my Lord. There is a part which is made bold. The learned counsel, your Lordship gets, my Lord. My Lord Justice Gawai gets, my Lord, the bold part. The learned counsel, appearing on behalf of the petitioners in the writ petitions, contended that it is clear from the provision enacted in Article 356, Clause 3, that the exercise of power by the President under Clause 1 is subject to the control of both houses of Parliament. The proclamation issued by the President under Article 356, Clause 1 would cease to be in force at the expiration of 2 months unless it is approved by both houses of Parliament. Prior to, my Lord, it was 2 months. Houses of Parliament, and therefore no irretrievable action such as dissolution of the Legislative Assembly of the state can be taken by the President before the approval of both the houses of Parliament is given to the proclamation. He also restricts that irretrievable action can be taken, but not before it is approved by both the houses. Otherwise, the parliamentary control would be defeated and it would be possible for central government to present a fait accompli to the 2 houses of Parliament, and neither house would be able to remedy the mischief done even if it disapproved the proclamation. Moreover, either house of Parliament may disapprove the proclamation even before the expiry of 2 months, and where that happens, the President would be bound to revoke the proclamation immediately because the proclamation cannot continue in defiance of the will of either house of Parliament without destroying the collective responsibility of Council of Ministers to the House. It was also, this is the contention, it was also urged that during the period of 2 months, no power can be exercised in virtue of the proclamation, which would bring about a final and irrevocable consequence if the President has reason to believe that either House of Parliament may not approve it, or also the control of the House of Parliament would be completely set at naught, and executive would be able to take irreversible action like dissolution of assembly by passing both houses of Parliament and ignoring their wishes.
In Rajasthan, state of Rajasthan, somewhat affected by the subsequent decision in Bomai?
Yes,
Because Rajasthan was 77. That was when Mr. Charan Singh wrote the letter to
Bomai, no, it comes subsequent.
And I thought that Rajasthan is substantially diluted by Bomai.
It is, my lord. That's what, that part I am going to read.
Yes.
But therefore, I have put it, my lord, chronologically so that your lordship gets everything at one, in one document without shuffling.
This is not the majority decision.
This
is Justice Bhagwati's decision, not the majority decision.
In Rajasthan.
Majority, I can show, this is a better worded from my point of view. Majority says the same thing. I'll show, my lord, those paragraphs tomorrow. So let's not, my lord, give off the cuff, my lord, answer. 165, I'm sorry, my lord. Let me not give off the, I'll put it, my lord, that way. It would be clear from this discussion that when a proclamation is validly issued by the President, same judgment, my lord, para 146.
All right.
I'll, my lord, give, I'm not reading, but I'll give the majority also, saying the same thing. But wording wise, I found this to be matching my submissions more. It would be clear from this discussion that when a proclamation is validly issued by the President under Article 356, Clause 1, it has immediate force and effect the moment it is issued, and where by proclamation the President has assumed to himself the powers of the governor under subclause A, he is entitled to exercise those powers as fully and effectively as the governor during the period of 2 months when the proclamation is in operation. There is no limitation imposed by any article of the Constitution that these powers of the governor can be exercised by the President only when they have no irreversible consequences, and where they have such consequence, they cannot be exercised until the proclamation is approved by both houses of Parliament. Here in this case, I must add, they are approved also when the decision was taken by both the houses on all occasions. Whilst the proclamation is in force during the period of 2 months, the President can exercise all the powers of the governor assumed by him, and the court cannot read any limitation which would have the effect of cutting down the width and amplitude of such powers by confining their exercise only to those cases where no irretrievable consequences would ensue, which would be beyond repair. When any power of the governor is assumed by the President under the proclamation, the President can, during the 2 months when the proclamation is in force, do whatever the governor could in exercise of such power, and it would be immaterial whether the consequence of the exercise of such power is final and irrevocable or not. To hold otherwise would be to refuse to give full effect to the proclamation which, as pointed out above, continues to operate with full force and vigor during the period of 2 months. It would be rewriting Article 356 and making approval of both houses of Parliament a condition precedent to the coming into force of the proclamation so far as the particular power is concerned. Now kindly see, my lord, only the bold part. It is true that once the Legislative Assembly of the state is dissolved by the President in exercise of the power assumed by him under the proclamation, it would be impossible to restore the status quo ante if the proclamation is not approved by both houses of Parliament. But that is the inevitable consequence flowing from the exercise of the power which the President undoubtedly possesses during the time that the proclamation is in force. Then again, my lord, only the bold part. It is therefore not possible to exceed. But rest I am not skipping because it's against me. I am skipping because I'm in a hurry. That kindly take him. If your lordship would like me to read, I can read everything. It is therefore not possible to accede to the argument of the petitioner in the writ petitions that during the period of 2 months before approval of the proclamation by the two houses of Parliament, no irreversible action such as dissolution of the Assembly of the state can be taken. The power to dissolve the Legislative Assembly of the state cannot also be denied to the President on the ground that the proclamation may not be approved by one or other house. In the first place, the existence of a constitutional power or the validity of its exercise cannot be determined by reference to a possible contingency. The court cannot enter into the realm of conjecture and surmises and speculate as to what would be the position at the expiration of 2 months, whether the proclamation will be approved by both houses of Parliament or not. Secondly, it is entirely immaterial whether or not the proclamation is approved by both houses of parliament, because even if it is not so approved, it would continue to be in force and effect for a full period of 2 months. But this is diluted in Bomai, SR Bomai. My lord, please come to page 150, next page, my lord. Justice Sawant and Justice Kuldeep Singh's judgment. (153), my lord, are the summary of conclusions. On this point, it is conclusion number 4, Roman 4. Since the provisions contained in clause 3 of article, am I with your lordship, my lord? On my lord Justice call, my lord, page 150. Since the provisions contained in clause 3 of article 356 are intended to be a check on power of the president and the clause 1 thereof, it will not be permissible for the president to exercise powers under subclause A, B, and C of the latter clause to take irreversible actions till, please mark this, my lord. This is the only dilution and this is the only limitation. Till at least both the houses of parliament have approved of the proclamation. And this is definitely the majority. So, Lord, here, when the actions which are impugned were taken, they passed the muster thrice. The proclamation passed the muster thrice. Then, my lord, then Justice Pandian, I find myself in agreement with the opinion of Justice Sawant on his conclusion 1, 2, and 4 to 8, with which Justice B.P. Jeevan Reddy concurs in his judgment. So this becomes, my lord, a majority view. And last, my lord, Justice Jeevan Reddy and Justice Agarwal, in light of the reasons given and conclusions recorded here in above, we find ourselves in agreement with conclusions 1, 2, and 4 to 7 in the judgment of our learned brother Justice Sawant, delivered on behalf of himself and Justice Kuldeep Singh. We are also in broad agreement with conclusion number 8. My lord, then Badrinath is the last judgment, my lord, I'll read. Only the first part, para 25. When an elected, my lord, your lordships have that?
Yes.
My lord Justice Gawai, yes. Page 150. When an elected government is not in office, the orders of the governor under Article 356(1)(a) as an agent of the President of India are equivalent to the orders that might have been passed by an elected government in office, and the governor's orders had to be given effect fully and could not be ignored either by the executive or by UPSC, etc. etc. Then, my lord, kindly come to, my lord, one paragraph of in SR Bomai at page 152. Justice Jeevan Reddy's, my lord, exposition on this at page 153. I'm not reading the rest, my lord. Your lordships may, my lord, it gives, my lord, what happens when 356 is implemented. Then at 153, fourth line from the top. My lord Justice Surikant and Justice Gawai has that page. I am on page 153, fourth line from the top. Coming to subclause B, your lordship gets that number?
Yes.
Coming to subclause B, when it speaks of the powers of legislature of the state being made exercisable by parliament or under its authority, it cannot and does not mean or imply dissolution of the legislature of the state. It is significant to note that the subclause refers to legislature of the state and not a legislative assembly. In a given state, the legislature may consist of legislative assembly as well as legislative council. In such a case, there can be no question of dissolving the legislative council since it is continuing body. Only the legislative assembly can be dissolved. In other words, there can be no question of dissolution of legislature of the state, the expression employed in clause B. The question may then arise, why was subclause B put in and what does it imply? Because entire legislation is not being dissolved. only assembly is being dissolved. And the court answers. The answer must be that when the government of the state is dismissed or removed from house, the legislative assembly cannot function normally. It is difficult to visualize a legislative assembly, or for that matter, legislature, functioning without a council of ministers, i.e. government. Thus, where the government of a state is dismissed or removed from office, or here resignation, the legislature of the state becomes ipso facto unworkable. It is for this reason that subclause B provides that powers of the legislature of the state shall be exercisable by or under the authority of Parliament. The best exposition, my lord, of sub-article B. So, my lord, these are my respectful submissions, my lord. I am immensely grateful, very patient hearing, my lord, and it's always a learning experience, my lord, before your lord.
Thank you, Mr. Solicitor. Thank you.
Lord, I wanted to read, my lord, the concluding speech of Dr. Ambedkar, my lord, at the conclusion of the assembly, the Constituent Assembly. But if time permits, at the end, my lord, I'll read for 5-7 minutes. It's a beautiful speech, my lord, at the end of the Parliament. And not right now, my lord, coming in the way of me.
Habits was very hard since while I was trying to read late at night through my iPad, still scribbling on the paper and then making some notes. So it's more than 61 years ago. We had, if you lordships recollect, I had given my 2 sets of written submission. Where is that at volume? Detailed written submissions, which is at volume 4. I don't propose to read at length but some essential aspects which I thought can supply by way of an addition to the arguments made before your lordships.
Which volume are you?
Before I do that, this is volume 4. PDF, it's a page, it's a separate written submission on behalf of the Attorney General for India.
That's volume 4.
That's right. And then I handed over a 2-page note on the last occasion with a summary of my submissions.
Your opening arguments.
Yes, yes. Which company? It's 61 years ago, we had Puran Lal Lakhanpal wanting to
whether he has any health problem.
Oh my God.
But not a very good compliment for me, my lord.
kept others alive.
Brother Gavi got worried, because he noticed that the same position persisted for 30 minutes.
Fortunately, he was the only one. Fortunately for me, he was the only one.
Fortunately,
Very good. Please. In continuation of my summary, your lordships have been taken through the whole historical narrations. And in matters like this, it's very difficult to capture their entire history. Through a list of dates narration, we want to communicate to the court what exactly happened for a period of 5 momentous years before 1950. And they convey only a very telescope point of view. And a large amount of literature which is available to all of us to say how this momentous process took shape. Through a variety of efforts and engagements and ideas and conglomeration of thoughts. But by and large, the history has been brought before your lordships. But for the narration of history, the understanding of not only Article 370, but with the constitutional integration process would have been incomplete. And that's where the detailed list of dates narration with the learned solicitor occupies an important space. Now, they said 61 years ago, Purnlal Lakhan Paul wanted to contest an election. Now, his dream has come true. He can contest an election in Jammu Kashmir. He had to wait for 61 years for all of us. All of us are Purnlal and Lakhan Paul, in a way. So this is a grand contribution to what one may say, but it's a very significant historical constitutional process that has taken place in the history of India. Now, why do we have to look at the historical narrative? Is that, of course, both sides would like to place a certain perspective on why a certain course of events alone are important. If you look at the constitutional integration process of the rest of the country and compare it to the constitutional integration of J&K, the historical narrative shows that there is no fundamental distinction at all. Is the political compulsions which happened in the context of J&K made a very slight deviation. And that deviation is, again, I would call a formalization of the principles and the procedures for integration. Article 370 is nothing but the outcome of the formalization of the principles and the procedures for integration. Well, the rest of the country had gone through all that process. Union of states, merger of small territories, and the idea of a constitutional assembly and framing a constitution of their own, all that process have gone through. But since there was little intervention, which is a political historical fact, Article 370 had to intervene. And if you try to attribute to Article 370 any other purpose or intent, then I think we're fundamentally mistaken. So we are asked to go back, I would probably ask you a lot to go back to 1949, 1950, and look at from the point of those who are engaged in framing Article 370, and with the visualization as to what would happen soon thereafter to the integration process of Article 370. Instead of that, we are sitting today, almost 60, 70 years later, and trying to imagine into Article 370 what contemporary context want us to imagine. I say that imagination to a large extent is forbidden. So we have to look at it from the text and context and the intent and content of Article 370. Let me quickly formulate my understanding of Article 370. I don't propose to read in extent so many of the judgments which have looked into Article 370. If your lordships kindly turn to my written submissions. Beginning. Page PDF, internal page 27 of my written submissions. And please turn before that to page 30, paragraph 9.
30.
The three dimensions of Article 370. A, you'll also have that page. A, enabling Parliament to legislate in respect of matters in para 1 and 2 of subclauses B of clause 1 of Article 370. B, application of the provisions of the Constitution of India, subject to exceptions and modification of clause 3 of clause 1 of Article 370. And C, termination of the role of Article 370 under clause 3 of Article 370. These are the three dimensions. Then the requirements of consultation, concurrence, and recommendation, as the case may be, are the processes to be followed by the President. And I think for the purpose of our understanding, it's unnecessary to go into the question of concurrence and consultation, etc., and the distinctions. But since we are debating on the proviso to clause 3 of Article 370 and the recommendation clause, we need to place some attention to that. In my understanding, let's kindly see the exceptions, modifications, additions, changes, power is, I think, virtually available in the entire spectrum of the Constitution of India in different contexts and for different purposes. But more prominently, when you come to the 5th and the 6th schedule, the legislation-making power of the governor has been noticed by this court on more than one occasion, and I'll place only one recent judgment. Kindly turn to paragraph 10 at page 30. This is the Constitution Bench judgment on the powers of the governor under the 5th schedule. Paragraph 39 and page 30, it begins at page 30. Your Lordships may skip forward to the next page and turn over to page 32. Middle of that page, page 32. There's a sentence beginning, the extent of the legislative power of the governor. The extent of the legislative power of the governor under Section 92 of the Government of India Act 1935 in making regulations for the peace and good government of any area conferred on the governor, in the words of Lord Halsbury, an utmost discretion of enactment for the attainment of objects pointed to. In that case, the words which fell for consideration Judicial Committee for the power of Parliament of Canada to make provisions for the administration, peace, order, and good governance for any territory, not for the time being included in any province. It contended that if any legislation differed from the provisions in England had been made for the administration of peace, order, and good governance, the same could not be sustained as valid. That contention was not accepted. And kindly turn over to the next page, page 33. The sentence beginning, applying the law, the middle of the paragraph. Applying law to an area is making regulations which are laws. So the power to apply laws is inherent when there is the power to repeal or amend any act or any existing law applicable to the area in question. The power to apply law is really to bring into legal effect sections of an act as if the same act had been enacted in the entirety. Application of laws is one of the recognized forms of legislation. You'll also find in Article 370, the application principle is virtually distributed in Article 370. I just presently read that. So the application principle of laws are recognized forms of legislation. Therefore, I would probably say that Article 370 conferring power on the President is not in the nature of an executive power of the President. The executive head is conferred a legislative power, a very extensive and wide power. The power to modify a parliamentary law, the power to subject a constitution to modification is a very vast power. And that's conferred on the president not as an executive head. And therefore, in order the president is enabled in exercising that power, we have only those processes to be followed: concurrence and consultation. So if the scheme was to have a provision to facilitate and aid the constitutional integration process, we need all that to put in place. The comfort and the aspirations also to be not to be compromised, and therefore you have a concurrence and a consultation.
Mr. Tony, if we accept that position, is something which we put to the other side. What has been the practice and the convention is something different.
No, that practice in fact flows from what the president was expected to do in order to complete the process of integration, the constitutional integration process. It is not linearly, unilaterally flow from the deliberations of the Constituent Assembly of J&K.
Oh, we understand.
It was not a sole authority, yes.
We understand your argument to the extent that there were conflicting views expressed in the Constituent Assembly, which is quite you have pointed out, or what was pointed out. And what we have today is Article 370 as it stands in the Constitution. So we have to interpret that and apply that.
Yes. We'll not kindly now turn to page 36, but we try to understand if this is a constitutional integration process. And the Constituent Assembly of J&K will play a role in the constitutional integration process. Now, how do you really make that happen? So that I said the two important elements of 370, namely extending the provisions of the Constitution on the one hand, and enabling Parliament to legislate in the meanwhile, as the Assembly is in the process of drafting a constitution for the state of J&K. Very essential, important steps of Parliament in the meanwhile will legislate for the state of J&K. And the extension of provisions of the Constitution are equally important. There are two limbs, important limbs. These are two important limbs in the hands of the president, and a terminus point will have to arrive at some point of time. I try to imagine that if Article 370 did not have clause 3 at all, it's impossible to think of a provision like this without a terminus point. Because it is not to serve a perpetual aid and advice position for the state of J&K through extending periodically, or what has happened over a period of time is, what the president has done is by updating various provisions of the Constitution by issuing various constitutional orders. The updating exercise went on till recently. Beyond the CO 54 1965, by which time the majority and important provisions of the Constitution were extended to the state of J&K. Beyond that, except on two occasions, it became contentious. They are merely updating exercises. So if Article 370 was to be conceived as a permanent updating exercise, one would have wondered why it should have come at the time of enactment of the Constitution or constitutional integration of J&K. It could take an entirely different shape. So that was certainly not the intention. So if a terminus point has brought in, and that power has to be necessarily vested in the president. Now Article 370 begins with a non-obstante clause. I understand, notwithstanding anything in this constitution, also house Article 368. Anything done within the scheme of Article 370, anything and everything done by the president, doesn't admit of any role for Article 368. So therefore, when Article 360 does not come into the scheme of the Constitution, the argument that during a President's rule under 356, you could not have probably taken any measure as reversible or irreversible without treading the path of Article 368 in this conceit. So if the realistic understanding of Article 370 was to complete a scheme, let's say at one level, enactment of the Constitution of J&K to the deliberation of the Legislative Constituent Assembly, and it must come to an end at that point of time. And if it came to an end by that point of time, because Sections 3 and 5 virtually captured the essence of constitutional integration, and nothing more required to be done after Section 3 and 5 becoming the part of the constitutional document. It hardly matters whether you call it today the Constitution, we will not get into the question at all. Therefore, if the integration process contemplated came to an end by enactment of Section 3 and 5 of the Constitution of J&K, that's at one level. At a different level, if thereafter President has issued various orders in exercise of powers under Article 371D, and if I am right in saying they're all essentially updating orders, except those two controversial orders, where Article 35A came, I ask myself a question: is the President precluded from taking stock of all that has happened under Article 371D and say, what shall I do with it today? That today can come at any point of time. There is nothing, therefore, in the scheme of Article 370 enabling or injuncting the President take this, ask this question. She is entitled to ask this question at any point of time. At any given point of time, if there is a trigger which facilitates and enables the President to take stock of the whole situation. So COs 272, 273, which are preceded by stock-taking authority of the President. The President has taken stock or whether what shall I do with Article 370? Should it continue or should it be called to have served its purpose and terminate it? If that authority of the President is untrammeled, the measures taken by the President to deal with looking for aid and assistance measures in terminating it, coupled with what the Parliament ultimately did in dealing with a very vast question of bringing peace and restoration to the state of J&K. So we are trying to tell you, Lordship, that justiciability probably will not come in. Now, let me try to understand why the J&K, the Constituent Assembly, was given only a narrow power of recommendation. Well, yes, it was necessary to have the recommendation taken from the Constituent Assembly, but that necessity does not enlarge the scope of the role given to the Assembly, which is a very narrow role, namely a recommendation role. One would probably be able to argue that if the Assembly, having dissolved itself, the proviso probably would have expired on its own. It's no longer operating. If it's no longer operative and cannot be operated at all, then can you say as the tail cannot wag the dog, etc. Although it is figurative, metaphorical. But what I mean to say is, does the President lose the authority and power available in Article 370, Clause 3, to bring to a close the entire scheme of Article 370? I would say the President has not lost that power. In the presidential poll case, question was whether, by reason of the fact that the Gujarat Assembly was dissolved, I presently play that citation, Gujarat Assembly was dissolved, and for the conduct of the election to the president, the electoral college is incomplete. And the election will be complete in a certain period. That's a mandate of the Constitution. But you can't do it now. Your Lordship in a 140 reference says, if the mandate of holding an election within a period now becomes impossible without an electoral college being available there, does not relieve the mandate from being complied with. So therefore, in certain circumstances, certain what called facilitating or what is called the recommending role of the Assembly is just not available. The President's authority under Article 373 can operate without any further assistance from any other authority. The President could have said under Article 371D, which is precisely what has happened here. He did not require any further assistance from any other authority. But by way of abundant caution, in continuation of what happened earlier under Article 371D, the President follows the same footsteps now, substituting Legislative Assembly in the place of the Constituent Assembly. So whatever gap, a suggested gap may be perceived, President says, now I'll fill that gap. There are several situations when such conditions, preconditions of performance cannot be performed. It's called the doctrine of impossibility. So therefore the performance is not relaxed, relieved. Performance will still be done. The conditions may be ignored. So therefore, if following an earlier precedent of Article 371D invocation, we had the substitution of Legislative Assembly in the place of Constituent Assembly, the President follows suit. It's also bear in mind when the role... Yeah, I lost it.
See, when it referred to subclause D to Article 371, to the government of the state. Now, if one has to take the concurrence of the government of the state, read clause 3 of Article 370 as giving complete and absolute power to the president will be virtually going against the entire object and purpose of the enactment, because otherwise clause D and the proviso says concurrent state governments becomes a formality. When we read that article, when we read clause 3 to Article 370, we cannot ignore the Article 370 clause 1, including D and the proviso, state government.
That's right. Right.
Not to the Sadr-e Riyasat, but Council of Ministers. Governor with the Council of Ministers.
Let me try to look at it from that angle.
So, if you're going to read clause 3 of Article 370 in isolation without reference to subclause D to Article 371, and then argue that this absolute power given, or absolute because there's the integration which has to be done, will it not be in conflict with, or not be in terms of the entire purport of the article itself?
The perceptions about this conflict arise because we are dealing with a provision which was meant to work during a certain period. And during the period, how it would have worked. And since it crossed that period, we have all these questions which are apparently in conflict. So therefore, if you go back to a period prior to 1957, and imagine what would have happened if the Constituent Assembly had recommended to the President to dissolve or to delete Article 370, partially or fully. Question would have been entirely different. So because it did not happen, we have to put in position a certain understanding as to make it, give it a meaning and context till ultimately President takes stock on that. So that giving a meaning and context and relevance will flow from what has happened over a period of time. And what the President can ultimately do in our understanding of the role and relevance of Article 370. And that's the most fundamental thing. Is the role and relevance of Article 370, regardless of its exercise over a period of time, is clearly understood by the President now. Then by what other normative yardstick about the relevance of Article 370 will the court judicially scrutinize the exercise of power by the President today?
Even if he, but in this case, is there any President's proclamation excising power under Clause 3 to Article 370? Saying that I'm abrogating Article 370.
I'll just come back. Can I come back to it by after reading of some part of in the line of my presentation? Kindly come to, let me complete this and come to your Lordship to answer your Lordship's question. Page 36 of my written submission.
Page 36.
We're talking about paragraph 12. We're talking about the recommendation role. I would just want to finish that part of the argument and then try to come back to this. Kindly turn to page 36, paragraph 12. Because if we try to extol the recommendation role beyond a certain level, then we are rewriting Article 370. So the recommendation role is a very minimal role. And how is it being understood in different contexts? We have
Does a recommendation postulate a positive recommendation, or does it mean just any opinion?
It is an advice. It is an advice. So it's an advice to facilitate and enable the President to find as to whether Article 370 has served its purpose and to close it. So the way the whole clause 3 of Article 370 is to render Article 370 inoperative.
But what
in that context?
Suppose there is a Constituent Assembly.
Yes.
We'll not go into this issue of the Constituent Assembly and the Legislative Assembly. And the Constituent Assembly recommends to the President, do not abrogate Article 370. Is it open to the President then to override the advice?
That power of recommendation is not available to the Constituent Assembly.
Sorry?
The Assembly has to only recommend the President in regard to rendering Article 370 inoperative. The President seeks that advice from the Assembly. The Assembly will not say, I have my different thinking on Article 370 and I'll ask you to retain 370 the way we want it. So therefore, the advice, the recommendation
is not just an opinion.
Yeah.
When the Constitution uses the expression recommendation, it means a positive decision, because Article 370 uses different phrases. It uses consultation, it uses concurrence, it uses decision, and it uses recommendation.
Certainly right. So therefore, the use in Article 370 of all these distinct expressions, concurrence, consultation, have their context. So therefore, recommendation is seen as an entirely distinct idea altogether. If the Constituent Assembly was to...
contending that even if the Constituent Assembly were to say that please don't abrogate 370, the President can still abrogate 370?
She can. She can. Recommendation is not binding on the President. Therefore, it is recommendation. It is not concurrence. So concurrence for the purpose of concurrence for the purpose where you get the provisions of the Constitution extended stands in a different thing altogether. Consultation where the Parliament will enable to enact during that period. Consultation. So recommendation occupies that it comes at the end of the day when all the parties have understood that the job of 370 is done, what shall I do? The president says, let me know what I shall do now. I want to probably say, I've taken stock of all the presidential orders issued. The constitutional integration process is over. Now, is there anything left by way of invoking Article 370 or extending the provisions of the Constitution of India to J&K? That question will have to be necessarily asked. When that question is asked, what is the role of the Constituent Assembly? So if the 370 had envisaged a larger role, that would have defeated the very purpose of constitutional integration. Therefore, the only relevant
Mr. Attorney, the use of the expression recommendation is not by itself dispositive of the content of the expression as to whether it is merely an advice, whether it is a condition precedent. I'll give you two examples. See, there are two examples in the Constitution where the word recommendation is used. Article 109 and 117. Yes. Article 109 deals with money bills. A money bill, after it is passed by is not introduced in the Rajya Sabha. Always introduced in the Lok Sabha. After the bill is passed by the Rajya Sabha, by the Lok Sabha, it is transmitted to the Lok Sabha, to the Rajya Sabha for its recommendations. Those recommendations are not binding on the Lok Sabha. It may either accept them, it may accept them in part, it may reject them. That is what Article 109 says. So in Article 109(2), see the way it is worded. The recommendation of the Rajya Sabha doesn't bind the Lok Sabha on a money bill. Now see 117. 117 says that a money bill cannot be introduced except on the recommendation of the President. 117. A bill or amendment making provision for any of the matters specified in subclauses A to F of clause 1 of Article 110, I'll go to 110 in a moment, shall not be introduced or moved except on the recommendation of the President. Now, in Article 117, the same word is used, recommendation. Recommendation is mandatory. You can't move a money bill unless there is a recommendation by the President. Now comes 370. There are many other provisions of the Constitution. I think, if I'm not mistaken, in my dissent in Aadhaar, I had analyzed those provisions of recommendation. Now see 370. It says, provided that the recommendation of the Constituent Assembly of the state
shall be necessary.
Shall be necessary before.
That's right.
Shall be necessary and before. So it's a condition precedent and a condition in terms of time. It can't be a post facto recommendation. It has to be before. What is the reason for it? There has to be a recommendation by the Constituent Assembly for the abrogation of Article 370. And second, that recommendation has to be before the President decides to abrogate it. Therefore, to say that, this recommendation is just an opinion, it's not binding on the President.
My submission is not to slight that recommendation role, but I say it's still only a recommendation. Let me try to explain. The necessity of having a recommendation does not add any further content to the role of recommendation. There is a procedure which is required because during the constitution integration process.
So your contention is that you have to have a recommendation,
yes,
and it's not binding. It may be a positive or negative recommendation. The President can override whatever is said by the Constituent Assembly.
No, the reason why, therefore, what I would call a minimal role of recommendation given to the Constituent Assembly is in the context of, one, the scheme of Article 370, and that being part of the larger integration process, can a body like the Constituent Assembly of J&K can have a final say on Article 370? It is not a constituent body of a Parliament of India. It doesn't have all that attributes and powers. So the recommendatory role has been assigned in the context, keeping in mind that once the constitutional integration process is completed, in the understanding of all the parties involved, there has to be a terminus. And to bring the terminus to a completion, then the role of recommendation is assigned. Otherwise, the Constituent Assembly could have been probably given the powers of consultation, concurrence. Why is state government coming into Article 370 at all? So it's only at the end of the day when you have done all that job. It's a stock-taking exercise. And it will probably envisage that you will do it before the constitutional integration process gets over.
What is the sequitur? Are you therefore contending that therefore, since this was purely recommendatory, therefore the absence of a recommendation also doesn't make a difference? Is that the submission or what is the submission?
I'll personally try to address the question. That's only when...
(103.2), yes.
There are different...
Qualifications. Wherever they want that the opinion or recommendation should be acted upon, they say so. It will be referred to the commission. Commission will give an opinion, and then it says, and shall act according to such opinion, which is missing in.
Act according to...
My note I have mentioned, I didn't read it, but the President of India being bound solely by a body which is outside the Constitution of India, Lord, may perhaps not be the correct interpretation of our Constitution. That if it says yes, he can do it. If he says no, President cannot do it. Because Constitution of Jammu and Kashmir is beyond and outside our Constitution.
Clause D does the same thing. It says that other provisions of the Constitution can be adopted subject to such modifications and exceptions. If they relate to the instrument of accession, consultation. Anything else, concurrence.
Of the state government.
Of the
not Constituent Assembly.
Not to the Assembly.
No, but then if the Constituent Assembly was not in existence, then it has to be placed before the Constituent Assembly for its decision. That means, even in the case of the operation of Clause D, read with subsection, with Clause 2, the Constituent Assembly is given the overriding power, even in relation to the President.
Till it survives, till it...
There's slight difference. See, you can't say when Article 370 itself refers to Constituent Assembly, you can't say that the Constituent Assembly is outside the Constitution. It's within the constitutional framework. Because it refers to it. Yes, your argument that once the Constituent Assembly is no longer there, what will be the position with regard to Clause 3 to 370 is something which we'll have to examine. With reference to the procedure you have, with reference to, because the judgments itself Many of the constitutional bench judgments still says we are not examining that issue. We'll have to examine.
No, only worry is, only with permission of the learned AG, the worry is, suppose this exercise would have been undertaken in 2007, in 57, when Constituent Assembly was in existence. Suppose it would have recommended that don't abolish, or don't abrogate, or apply with modification that none of the provisions of the Constitution of India would be applicable, or never apply fundamental rights with that modification. I'm putting a question to myself, the President of India will be denuded of its powers? Was it intended that by not recommending not to abrogate, it would become permanent?
We have taken that argument.
In other words,
That proviso will no longer be applicable after the Constituent Assembly is not there, but that will not deprive the President of his power under Clause 3.
in other words, if the object and the role of Article 370 is essentially and fundamentally a constitutional integration process, anything which emanates from the Assembly, to the contrary, as a way of negation of the integration process, would be forbidden under the scheme of Article 370. You can't have a negation there.
Mr. Tony, you extended that argument, therefore the questions arose. You extended the argument to say recommendation only means advice, and even no advice. Suppose the Constituent Assembly was, that's assuming that the Constituent Assembly was
Therefore,
there.
I quite see.
That part, the extension part is the one which is...
We have to probably understand the context in which why this provision was at all enacted. The Constitution integration process repeated was the only mantra under Article 370. And everything around it revolves around it. 371, A, B, the Parliament is enabled to legislate, extension of provisions of the Constitution, they all revolve around this central theme.
See, the only thing is in relation to Jammu and Kashmir, one thing is very clear from reading Article 370. It expressly recognizes the instrument of accession. Categorical recognition of the instrument of accession in Article 370 itself. Second, a categorical recognition in Article 370 of the process of the formation of the Constitution of the state of Jammu and Kashmir. Third, a categorical recognition of the status of the Constituent Assembly of Jammu and Kashmir. So therefore, it's not that these were instances which were taking place as a part of the realpolitik in that state. The IOA, the Constituent Assembly, the process of constitution formation in Jammu and Kashmir, they are expressly recognized in Article 370.
You're right.
So they have been conferred with a certain constitutional recognition, if not a constitutional status, a constitutional recognition in Article 370.
I just want to enter a small caveat because the historical narrative about what happened in the rest of the country towards constitutional integration. As I said, essentially the process was one and the same. Constituent assemblies.
You are right, Mr. Attorney General. You are right, Mr. Attorney General, to the point that this was in aid of constitutional integration.
Yes.
And as we see that integration was taking place by and by, from 1957 right through to 2019. So subjects which were completely excluded to the Parliament were brought in within the purview of Parliament. That was also a clear understanding of the constitutional movement towards greater integration of Jammu and Kashmir into the Republic of India and the Dominion of India originally, and the Republic of India. So there was undoubtedly a gradual and imperceptible integration, apart from the unconditional accession to India, which we saw right at the outset in Article 3. There's no difficulty about that. But the only point really is this, that there are two ways of looking at Article 373. If the proviso can't apply, we keep 367 apart for a moment. If the proviso to Article 373 cannot apply, does that mean that the power under the substantive part of 370 is completely denuded or lost?
No. The answer will be no. I'll try to.
That's the
power is not lost.
And if that power is not lost, is it a unilateral power then which can be exercised by the president? What Parliament really did was this. They didn't have a constituent assembly in the state of Jammu and Kashmir. There was no constituent assembly. They were exercising this power to abrogate. They followed the 367 course, obviously, with an idea that in the absence of a constituent assembly, there's no legislative assembly in the state. You go to Parliament, which in that sense represents the broad diversity of
the decision.
You have the Rajya Sabha, which is a council of states,
Correct.
which represents the overall diversity of the nation. You have the Lok Sabha, which consists of elected representatives of the nation. But in that process, there's one, I wouldn't say casualty, but one dilution. And that dilution is the role which was ascribed by the proviso to Article 370(3). Now, that role can, as you are trying to elaborate, that role is merely recommendatory. Merely because that role is recommendatory does not mean that it can be dispensed with, because the Constitution provides for a recommendation. When a Constitution provides for a recommendation, we can't say that, well, even if there's no recommendation, that's fine, you can override it.
My endeavor is...
Can I just add one thing? Sorry. Sorry to interrupt. You see, after you amend 367 and say legislative assembly is equal to constituent assembly, we have to take it to the logical conclusion.
Right.
We've accepted that it exists, but
That's right. That's how it has.
But my lord, only one question, my lord, and your lordships can consider this, my lord, during this holiday. My lord, suppose in 1957, at the time when the Constitution was framed, Constitution of Jammu and Kashmir,
Yes.
and the Constituent Assembly was dissolving itself, last speeches were made, etc. Suppose it would have said that now, in exercise of our powers under 370, sub-article 3, we recommend the President that the constitution which we have framed, which provide for a semi kind of monarchy, and now therefore you delete 370. Lord, would it not go against the very spirit with which 370 was incorporated? That it has to be temporary and you are an integral part. Because 370 sub-article 3 says, notwithstanding anything contained in the foregoing provision, meaning thereby 1 and 2, instrument of accession, and Article 1 being applicable. So, Constituent Assembly technically was not bound by 1 and 2. It could have said, then, my lord, would the President be completely denuded and act as per the desire of the Constituent Assembly? It cannot be, for the simple reason that the debates in the Constituent Assembly repeatedly say that this is a temporary provision.
So that's why I said you can't.
You don't have to refer to the debates.
So that's why I said there can't be a negation principle read into the proviso. A principle of negation whittling down the entire scheme of Article 370. You can't read it into the proviso.
Let us say, that as Sheikh Abdullah at that time wanted that independence resolution being passed. That's why you put in registered of the assembly.
It's the very that answer is given in the Article 370.
Had they proposed, then the President is not bound.
No. That proposal is not. This will be contrary to Article 370.
That's right.
May I have your lordship's permission in support of this submission?
Contrary to Article 1 also.
Reading material can be shared with.
Kashmir is the interior part of it.
That's all right.
Question.
Some reading material can be shared with your lordships, and then
No, nothing in terms of reading material, Mr. Attorney.
We have enough reading material with us.
Now we will go by churning material, which we have at the bar.
I didn't want
because then in rejoinder we'll get a couple of thousand pages, Mr. Attorney, and we only know what difficulty that poses at the end to us.
Coming through that, I understand.
If I give you a more accurate list of days.
These are some.
We put that discipline on you because we realized what could happen.
No, but what happened?
That was
So the facts which are on record in the work of Sardar Patel.
This is please let us not get into that. I don't think
Please, Sybil, you will have your chance
I don't think this statement is necessary at all. The reading may change with some excerpt from certain books. Some thoughts come in the course of how do you explain internal sovereignty, how do you explain certain. I thought if they are useful, I can certainly.
One last word, and then we'll rise. Of course, then we'll think of all that you've argued for the holiday tomorrow. That the wide chasm between absolute autonomy, as it existed on the 26th of January 1950, all right, and complete integration, as it was brought about on 5th of August 2019, that chasm had been substantially bridged by what was happening in between. So really, in the sense, it was not a complete migration from absolute autonomy to absolute integration.
It had become a shell, my lord, as
whether you call it a shell or not,
Gulzarilal Nanda said.
It's obvious that a substantial degree of integration had already taken place in the last, between 1950 and 2009, 69 years. And therefore, what was done in 2019, was it really a logical step forward to achieve that integration?
Absolutely.
Integration was whole already. The power in 1950, only assimilation was different meaning for us. The power to make those.
We have interesting issues, yes. We have interesting issues. Mr. Attorney, about how long would you take? About half an hour or so now?
More if possible.
Sorry?
Maybe an hour more.
After that, Mr. Dwivedi will.
Right.